called upon or need to speak to the meeting? Okay, are we ready?
Cynthia, you're very, very muffled. I don't know if anybody else is having that problem hearing her.
Okay,
Yes.
is this better?
No.
A little bit,
Okay.
not much.
Chris June Kiliani. Professor Ann Trom.
Here.
Laura Fitzsimmons.
Here.
Rob Tellis.
Here.
Julie Kavanaugh Bill.
Here.
Joni Easley.
Yep.
Lorinda Wichman.
I'm here.
Dave Mendiola.
Here.
Jeff Wells.
Hi there.
Drew Christensen.
Here.
Kate Thomas. Justice William Moppin. And Mr. Bevan Lister.
I am here. Thank you.
Okay, we have a quorum.
All right. Can you hear me?
Yes.
Good. Okay, great. So welcome everyone. Thank you for making time. We have a lot of agenda to get through, but hopefully we can quickly. I'm hearing some interference, so if you're not speaking, if you could mute yourself, that would be really helpful. So the first thing on our agenda is public comment. We allot 3 minutes for people who are attending. We also have accepted, I think, email comments. But I wanted to say that we would like to have our public comments today focus on sort of global comments. If you're attending the meeting in order to weigh in on the regulations and make comments on them, we will hear those comments as we move through the workshop when we get to that part of our agenda. So if you have global comments, you're welcome to make them, and they're limited to 3 minutes. Does anyone have a comment?
Hi, this is Jonelle Thomas from the Clark County Special Public Defender's Office. I'm hoping to be able to respond item by item, but I did want to say we have a 2 p.m. hearing in front of the Nevada Supreme Court this afternoon. So if we don't get to particular items, I believe most of the institutional public defenders are going to have to leave for that meeting. But we have submitted written comments on each of the items. So I'm hoping that we'll get to the items before 2, but just wanted to give you a heads up if we disappear. Thank you.
Thank you. And I just wanted to say briefly to that, I think that we can probably get to them in time, but if we're getting close, we can always just change up the order in order to get to the key comments before 2 p.m. So we'll just keep our eye on that. But thank you very much for your comment now and also for the written comments you submitted, and we look forward to hearing more about those as we move through. Thank you. Does anyone else have is there any more public comment? Okay, hearing none, I'm going to go on to number 3 on the agenda, which is welcoming our new.
Madam Chair, did you want to ask Ms. Attanasio if she received any additional written comments from the items that were sent?
Ms. Attanasio, did you receive any additional comments from by email?
No, Madam Chair. Just the ones that have been previously submitted to the board.
Okay, so we did receive some comments which were circulated on the regulations. Those comments were submitted by Jonelle Thomas, the Special Public Defender, who we just heard from Clark County, and they were representative of other institutional defenders that she referenced. And then we also received a comment, I believe, from the Washoe County Public Defender and Washoe County Alternate Public Defender, also on the regulations. So we'll get to, I expect to hear more about that during the meeting, and those were circulated. Okay, thank you. So we're moving on to number 3. We'd like to welcome Bevan Lister. Mr. Lister, are you? Oh, there you are. Great. So welcome. I understand that you are the new appointee from NACO. And are you based in Pioche? And would you like to just tell us a little bit about who you are, to just introduce yourself to the board? That would be wonderful.
Certainly. Thank you, Madam Chair. Just a little bit about me. I'm an engineer by education, a welder by training, a farmer by choice, and a policy junkie by addiction, I guess. I sit on the board of Lincoln County Commissioners and got the nod from NACO to sit in with this board, and I'm pretty well undergunned here. I can see that I'm in a pretty elite group, and I'll keep my mouth shut and try to learn something.
Well, we welcome you to the board and thank you for your service. And you kind of picked a doozy of a meeting to start. So
yeah, I see that.
But we're very happy to have you here. So thank you for spending the time with us.
Hey, Madam Chair.
Yes.
Could the minutes please reflect that Kate Thomas has entered the meeting?
I did not understand that. Can you say either Ms. Thomas or Ms. Juba, can you say, go ahead.
Oh, I just wanted a record that Kate Thomas has entered the meeting.
Oh, great. Okay. Thank you. Okay, so number 4 on our agenda is a vote for the new chair and vice chair. This is obviously due to I am currently acting chair, and we need to sort of have a vote on this that we delayed last time. So I think our practice has been to take nominations. That's I think how we've dealt with this in the past. So are there any nominations for, maybe we should go first with chair and
Chair.
Vice chair. Yeah.
Madam Chair, this is Lorinda Wickman. I'd nominate you to remain as chair if you're willing.
This is Laura Fitzsimmons. I would second.
Okay. I am willing. Should we then talk about, should we nominate vice chair at the same time, or should we vote on each first? You want to vote on each first? Okay. Are there other nominations? Okay, hearing none, I guess, I don't know if I'm allowed to conduct this vote. So those in favor of the nomination or the motion that's standing?
Aye.
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 Anyone opposed? Okay, very well. I guess I'll continue now as chair instead of acting chair. How about on vice chair? Is there a nomination for vice chair?
I have.
Yes, Madam Chair, I'd like to
This is
nominate
Lorinda.
Dave Mendiola.
Good.
I'll
Second.
second that. This is Lorinda.
Okay.
Oh, sorry, Miranda, you go ahead. We're all jumping in, Dave, to nominate you.
You're just assuming I care.
Dave, are you willing to serve?
Yes, I am.
Great. Okay. Any other nominations? Excellent. All in favor of Dave Mendiola serving as vice chair?
Aye.
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 Anyone opposed? Excellent. So thank you to Dave Mendiola. I'm happy to serve. And it's great to have Bevan Lister here so that we are now a full board with an actual chair and vice chair. So thank you, everyone. Okay, let's move on to the workshop. We really want to make this to go as efficiently as possible. And we really want to hear from the people who want to weigh in so that we are actually just getting closer to the best regulations that we can have. So what we have proposed is that we will go sort of section by section. We did circulate a PowerPoint. It sort of breaks up the proposed regulations into smaller chunks. what we anticipate is that we'll hear first from the department on each of these smaller chunks. The first two we might group together, but the other ones will take sort of section by section, not regulation by regulation, but section by section, and then we'll hear from he'll comment on those sections. And we hope that this goes efficiently. If it doesn't, of course, we can adjust to make sure that we're getting through the material and hearing from everyone as needed. So I would like to hand this over now to Executive Director Reba and Jared Hickman. They are going to present. So we'll hear first from the department, and then we can have comments on the sections that they've addressed, and then we'll move on and hear comments on those. Okay, so Director Reba, do you want to take the floor? Or are you presenting first, or is it?
Yes, I'm going to go first. So
Great.
Good morning, everyone. I'm so glad that everyone is able to be here today to discuss these regulations. In preparation for this meeting today, we kind of looked at some historical information of the Sixth Amendment report that was written by David Carroll, and I just wanted to take an opportunity to remind the board members of some of those recommendations that David Carroll and the Sixth Amendment Center wanted us to ultimately make a recommendation of. And that is that they were encouraging the state of Nevada to authorize our department to promulgate standards, including but not limited to attorney qualifications, attorney training, early appointment of counsel, attorney supervision, attorney workload, uniform data collection and reporting, and contracting. And these standards should undergo public comment and then ultimately be approved by the board. So that's what we are hoping to do today when we're going through our regulations and the way that we broke it out. But before we get into that, I did want to give everyone a little bit of a roadmap of what to expect next. So we have our department proposed regulations, which is that LCB file number R042-20, which everyone has received a copy of. As you can see from the PowerPoint and the department recommended revisions, we are asking that certain changes be made to those regulations that came back to us from the Legislative Counsel Bureau. If the board adopts the changes that public comment or that the board is recommending, our next step would be to set a public hearing, and we have to give at least 30 days, and these would become temporary regulations. Now, temporary regulations is not a bad thing. It might actually be a better thing for our department, so we can try out these regulations and we can see how these things are working. If these turn into a temporary regulation, they'd be valid until November 1st of 2021. So we'd have until that time to see how these regulations are working, decide if we want to make any changes, and then ultimately we can send these regulations off to LCB at a certain time in an attempt to make them a permanent regulation. And we'll have to go through this whole thing over with the public hearing and the workshop. So if these changes are made today that we're recommending, the road that we're going to go on is to make these a temporary regulation. If the board in the alternative would prefer to accept the language as it was returned from the Legislative Counsel Bureau, the road that we would be on would be to make it a permanent regulation. So the key is whether or not we're making substantive changes to those regulations that are being returned. And Sophia Long from the Attorney General's office is here to advise us if she thinks we're making substantive changes or if we're not. Ultimately, we are recommending certain areas get added, certain language be completely deleted. So likely if you go along with the department recommendation, it would be that substantive change, and it would take us into that realm of temporary regulations. So in addition, I have that PowerPoint that I've provided to everyone. I'm open to comments as to whether you would like to see the PowerPoint as we're speaking, or if you would prefer to have it be not shared. So I'm going to start with sharing it. And if the board would like to do something different, I'm all ears and I'm willing to take it down. We don't necessarily need it up because I did distribute it to everyone. So at this point in time, I'm going to share my PowerPoint. And as I said, we changed these into 3 separate or into multiple groupings. You can see that sections 1 through 10 are definitions. Sections 11 through 17 are declaratory rulings and petitions. 18 through 21 is financial reporting. These are the sections that I'm going to be covering today. 22 to 26B is contents of plans. 27 through 39 is attorney qualifications. Those are the sections which Jared Hickman will be covering. 40 is the review, audit, and investigation. 42 to 43 is economic disincentives and contract terms. And 48 to 50 is uniform data collection. And those three sections will be covered by Patrick McGinnis. So ultimately, the reason that when we initially sent these way back in March, we've done a lot of investigation, reaching out to other agencies, and we kind of thought that there were a lot of holes that we could really clarify and fill in. So with our proposed recommendations today, what we're trying to do is kind of make it more clear what we're trying to achieve by these plans, make it more clear what needs to be in a contract, and make the economic terms and everything more clear. So that was ultimately what our desire was to do. So moving on to definitions. Hold on.
Madam Chair, this is Ms. Kavanaugh, if I could speak real quick.
Yes.
Ms. Ryba, if you could point to the page you're on, the video was not working from my end, so I've got the PowerPoint up, but it would just be helpful if I knew the page that we're on.
Right now I've turned to page 3, which is definitions, sections 1 through 10, and it should have definitions section 1 through section 4A on it.
Thank you.
And I can let you know when I'm changing the slide if that'll assist.
So Marcy, this is Jeff. I don't know. I went through the actual draft thing, and so that has different page numbers than your slide has page numbers. And so I don't know which is going to be the better system to try to track it. So I'm willing to do either because I have the slides, but I have my notes on the actual hard copy. So I don't.
Well,
if we're going to do page numbers, we might have to do both.
I think that Ms. Kavanaugh Bill was referring to the page numbers on the slides for the PowerPoint. But I can keep it down and we can just discuss if that's preferable. Madam Chair, which would you prefer?
That's fine for me. I actually just prefer seeing people's faces. I think it's a little bit easier to see them when we're just discussing. And I think if we get into a moment where it's just helpful to see the language together and talk about the language, then we can put the slide up. Is that helpful?
That's fine.
Okay.
Okay, so in beginning with the definitions, a lot of these definitions we took from either borrowing from the Clark County plan or possibly from the Indigent Defense Data Dictionary. So these words that we used and that we defined have been defined in other places. As you can see, we are requesting no changes to section 1, no changes to section 2, but we are requesting that section 3 be deleted as we've changed our focus to screening rather than appointments. Appointment seems to be more derivative of what a judge needs to do. Section 4 and 4A have no changes. Section 5, the definition of a case. Again, this is from the Indigent Defense Commission Data Dictionary. We are requesting a change to add language of in need of supervision when it comes to discussing a juvenile, and that's more consistent with our definition of indigent defense services in NRS 180.004. Section 5A, we are asking to add a definition of department, so that's clear. Section 6, we are asking to delete the definition of delivery system as it was not used throughout the regulations and did not deem a definition necessary. There are no changes to Section 7 and Section 8. Section 8 definition is directly from 80 KT 411, as well as the case of Brown v. District Court. Section 9, there's no request for any changes. And Section 10, we are requesting to delete the language of subsection 1, 2, and 3 because we felt that it was too limiting on what a plan was. A plan is actually more than just those 3 things. So we felt it was more important to define it as the provision of indigent defense services in accordance with these regulations, because the plan is more thoroughly defined in sections 22 through 26B. Moving on to sections 11 through 17.
Marcy, can I back you up to section 10 for a second?
Yes.
So, and this is more of a sort of technical question than a language question. I have no problem with your language per se. We basically are an executive branch department created by the legislative branch. And yet there's long established case law and precedent that it's ultimately the judicial branch and the Supreme Court that controls the practice of law in front of those courts. I'm wondering if we need to say in section 10 that these plans have to be, and it would show up a couple other places, this is just the first time to bring up this debate, is whether it needs to say it's going to be in accordance with these regulations and ADKT 411 and any subsequent pronouncements by the Supreme Court. I don't want to get us into a position where we have adopted rules or guidelines on the practice of law that are different than what the Supreme Court wants.
We try to incorporate, I mean, I think the question is what specifically about ADKT 411 is after the attorney performance.
And I think if you review sections 22 through 26B, it does discuss ADKT 411 requirements in there. And, you know, if you would like to add that language, this is just merely a definition, which is a very general term. And the plan is more thoroughly defined through sections 23 through 26B. But is there a certain section you think that should be added of ADKT 411, or would you like just language that says it? Because it is discussed later on in 22 through 26B.
It is, and Marcy, that's what I said. I didn't really have a problem with the language right here because it is definitional. This was just my opportunity to bring up the theme. If the Supreme Court makes a new ADKT 609 someday off into the future, we need to have some language somewhere in here that makes it clear it's subject to ADKT 411 now and any further pronouncement of the court. I don't care where you put it. Doesn't have to go in a definitional section. It was just sort of a philosophical thought.
So one possibility is to kind of, this is just the definition. So one possibility is to kind of bracket language that might work and then decide where it goes.
Right.
So perhaps that I would suggest maybe as a bracketed language, just for the moment, as a placeholder, something very general like and applicable law or laws, because anything that you're talking about would be law, right? I mean, it would be either a pronouncement from the Supreme Court or a new case law from the US Supreme Court or from the Nevada Supreme Court about what's what, or, you know, that's governing law. So I don't know if it belongs here, but I would suggest something very generic.
That would be fine.
And broad, yeah. And then we can decide, maybe we can circle back to see whether this is the place where, if it belongs in the definition section, which might not usually have that kind of force, but be definitional. So that's a useful comment.
Chair, that's the end of definitions. Did you want to take public comment on definitions before I move into the next section?
So the next section is just 11 through 17.
That's correct.
I think it's useful to go on through 11 through 17 and then take comments.
Madam Chair,
Okay.
This is Drew. Madam Chairman, this is Drew Christensen.
Did we lose Madam Chair?
Ann, can you hear me?
She
Marcy,
appears.
can you hear me?
Yes, I can hear you. Madam Chair appears to be offline.
Okay.
I hear you,
I
Drew.
figured I'd bring it up now. I just had a note to myself on the definitions of section 8. Further enhance the definition of indigency If you look at ADKT 411, it went on to enhance that if you don't fall in one of these categories, that there's a more rigorous screening process of finances to determine if someone's indigent. And I thought that would be a good idea to include that in the definition language as it was defined by the Supreme Court back in ADKT 411. So just a thought. We have a form in Clark County that the courts use, and the current definition is kind of what we refer to as page 1 of the determination of indigency. If they meet one of those qualifications, they're presumed to be indigent and appointment is forthcoming. If they don't, we refer to page 2 where it's more of a financial information sheet that the Supreme Court has said to look at the charges, the seriousness of the charges being faced, the local council rates, and then the court can make a more rigorous determination if their current situation would still allow them to be indigent. And I think it may be appropriate to add that additional language from ADKT 411.
Hello, Drew. This is, for the record, this is Jared Hickman. I'm looking at ADKT 411, specifically the January 2008 order. And I think the language you're referring to, just to make sure we're all on the same page, is defendants not falling below the presumptive threshold will be subjected to a more rigorous screening process to determine if their particular circumstances, including seriousness of charges being faced, monthly expenses, and local private counsel, would result in a substantial hardship whether to seek to retain private counsel.
That's exactly the language. I was just thinking because you've taken basically the first part of the definition and just add that second paragraph as the Supreme Court did.
It appears Professor Traum is back on.
I'm back, yes.
So Professor
Hi, Professor,
Traum.
while you're gone, yeah, I was just adding potential new language to the definition of indigency.
In section 8?
Section 8, correct.
Yeah, okay.
So if there's no additional comment, I can move on to sections 11 through 17 if everyone is agreeable.
I think that's good.
So sections 11 through 17, these are basically set forth by, we're reading the administrative rulemaking procedural guide, and it does set forth that every agency is required to adopt regulations for filing and disposition of petitions for declaratory orders and advisory opinions as to the applicability of any statutory provision, agency regulation, or decision of the agency. So every agency that's a rulemaking agency, such as ours, is required to have these regulations, and these regulations are taken directly from the Administrative Rulemaking Procedural Guide and are recommended. Sophia Long, the DAG, also approved 11 through 17. So 11 through 17, we are not requesting any changes from what was returned from LCB.
And we can hear comments in a minute, but did you receive any comments prior to this meeting on 1 through 17?
I have not received any written comments on 1 through 17.
Okay. So I guess now would be a good time to ask for comments at this meeting, if anyone has them, on 1 through 17. Okay, so hearing none, I think we should go. We should go on to the next section, which is 18 through 21, and I anticipate we will. We did receive comments in that section, and so we may hear more. But what Director Reba wanted to proceed with that?
Thank you. So sections 18 through 21 have been grouped into the financial reporting and maximum contribution formula. Just to remind the board, pursuant to NRS 180.320 subsection 3, the board shall adopt regulations to establish a formula for determining the maximum amount that a county may be required to pay for the provision of indigent defense services. We are recommending certain changes. The first change is we are recommending that it be divided, the formula be divided into two parts. The first part is in counties whose population is less than 100,000, and the second part is counties whose population is more than 100,000. Now, the reasoning for this is the board has recommended that any costs related to murder or capital offenses be deducted from that maximum contribution formula. And in talking with interested parties, it was felt that if Washoe and Clark County's expenses for capital and murder cases were deducted, that it would put a significant burden on the state for an amount to pay for those cases. So that's why we changed it into two. Also, when these regulations came back from LCB, we had submitted them as fiscal year 18, which is 2018, and fiscal year 19, which is 2019. But the LCB changed to fiscal year 19 and fiscal year 20. So we are asking that if the board would like, that we revert back to those original numbers. We also wanted to point out a couple of issues that we felt, and I think that this is something that really needs to be discussed with the board. We have reached out to all the counties to ask them how much they spent on indigent defense services in fiscal year 18 and fiscal year 19. And remember, indigent defense services is defined as NRS 180.004. And that's kind of a limiting definition because it does not cover everything a public defender is expected to do. For example, 432B cases, involuntary commitments. Some public defenders handle termination of parental rights. All these things are covered by public defenders, but they're not included in the definition of indigent defense services. So when we reached out to the county, we did ask them to fill out a financial reporting form and to certify that all of these were explicitly used for indigent defense services. But I think the biggest problem we have is counties were not requested to keep records specifically to indigent defense services. So they could tell us generally how much they spent as a whole on public defense, but I think they're going to be unable to take it back to specifically for indigent defense services. And this problem arises because in some counties, they've contracted with their public defenders to cover all cases, 432B criminal cases, and they did not require any timekeeping. So trying to extrapolate how much of that attorney's contract was for indigent defense services versus how much was for 432B action is going to be an impossibility because there's simply no records of how much was spent. So in trying to determine an accurate maximum contribution number, some of the counties were having issues giving us very specific numbers as to what they spent on indigent defense services specifically. So that might be one issue that this board might have in finding an accurate number. If we go along with what they've recommended again, or what they've provided us, again, this amount they provided us includes what they spent on 432Bs and other things. So the counties may be paying a higher rate in this maximum contribution formula if we use those numbers than what the board had intended originally. So those are some concerns that we've received for that. Another concern that we've received is in subsection 4. We recommended that the state public defender, rural counties be able to send their death penalty cases and direct appeals to the state public defender, and that those are a state expense. We have received concerns that if we make this exclusively a state expense, that it could encourage some district attorneys in rural counties to file death penalty cases, as the expense would be kept by the state rather than by the local county. The same individuals that made that comment were agreeable to having appeals be transferred at state expense to the state public defender. They felt that there might be more appeals coming out of it in the end if that were to be done and if fees were to be covered by the state. So as a possible recommendation, if the board is in agreement with that recommendation from the interested party, we could possibly split up subsection 4 into two sections. One section that discusses death penalty cases and another section that discusses appeals. And whether or not those are state costs or whether or not those are county costs, I guess that would be up to the board to decide. Now, if we look again at the maximum contribution formula, even if we make death penalty cases a county expense, counties are still limited by that maximum cap. So there might be some sting if they file these death penalty cases, but it's not necessarily going to be as significant as they would have felt otherwise with this maximum contribution formula. And then, as you can see, I did set into subsection B that amount for the counties over 100,000 to just be the average of fiscal year 18 and 19. We did add language. The union negotiated cost of living. An interested party made the recommendation that we added language saying it was the lowest union negotiated cost of living. It was pointed out that in some counties, there's multiple cost of livings that are negotiated. So if you clarify by the lowest, then it would clarify which one we would be applying. So I don't know if you want to discussion after that, or if you want me to continue on with 19, 20, and 21.
Madam Chair, this is Ms. Kavanaugh Bill.
Go ahead.
So I have a question on subsection 4. And I think it's just the way it's written, that last clause after the change. It says investigator fees and then comma. In those cases must be a charge against the state. I don't know if we're missing a word there or what, but are all these costs, if the county chooses to transfer the death penalty case to the state public defender, this provision is saying that all costs, including the costs related to expert or investigator fees, must be a charge against the state? Because it has that in those cases. I'm not sure if it's just grammatical.
And Ms. Kavanaugh Bill, I believe that what we're trying to clarify is the language before says the cost of providing indigent defense services. So that would be the defense of those cases, including costs related to expert or investigator fees, comma. So I guess we could take out in those cases, and then it must be a charge against the state.
Thank you.
Ms. Reba, could you just clarify for a second how that works with, I'm just a little bit unclear on tracking. Are those going to still be, are those charges still borne by the state, or do they fall under the maximum contribution as you've just discussed?
I think it would depend upon whether or not this board is considering those to be a county expense or a state expense. So if they're a state expense, they would be a direct expense to the state. So we would have to build into our budget the ability to have a unit that could handle these death penalty cases within the public defender's office. And that would require retaining 2 highly qualified attorneys, a mitigation expert, an investigator, and likely some secretarial staff. So that would include a request to build up the public defender's office to handle these cases. We should also note that we have heard from counties, and this is a big concern for the counties. They almost want an insurance policy that if one of these death penalty cases comes up, they have the public defender that they can call to bring in, so they know that it won't necessarily bankrupt their county. So that's what's been thrown around by a lot of the counties, is trying to protect the bottom line fiscally so that, you know, they're not bankrupt. And I think Mr. Mendiola can expound upon that.
Yeah, Madam Chair, Dave Mendiola. Yeah, my comment on that would be, as I think that everybody budgets for a reasonable amount of money for a capital case like that, as well as investigative fees and the like. But in the end, you know, those are reasonable. And some of these, we just had one last year that was very complex, and it would have cost us, we think, about $500,000 to defend that particular individual. Fortunately, it was settled out of court and all is well. But I think we all budget, you know, for relative expenses. But these kinds of things would definitely put you well over the max for even one case. in our case, I can tell you that. So, Madam Chair, I also have one other question back to Ms. Reba. And that is, I was a little confused on the explanation of the maximum expenditures by counties. And again, maybe I just misheard you, but you were talking about some things are not covered currently. Some counties don't budget for like 432Bs and the like. And I would just say, at least, again, we have a public defender administratively, and so we do include those as part of the numbers we gave you. So that's just part of what they do. And I would assume even if it's a contract attorney, that again, they're contracted for doing the work. So I just don't, I guess I'm a little confused as to why somebody would reported, you know, a maximum amount, but it didn't include 432Bs and other types of cases. So maybe you could clarify that for me.
And Mr. Mendiola, thank you. That's exactly what the issue is with the current definition of the maximum contribution formula. If you look at NRS 180.004, it defines indigent defense services as the provision of legal representation to an indigent person who's charged with a public offense, so a crime, or an indigent child who's alleged to be delinquent or in need of supervision. The problem is that the way that the statutes are written, public defenders are commonly appointed in 432B cases, involuntary commitments, termination of parental rights, and those are not included within our definition. So if we look back to NRS 180.320, the maximum contribution plan is limited by indigent defense services. So we have to tell each county the maximum that they're going to pay for indigent defense services. And it doesn't appear that we're able to increase that amount to everything a public defender does. It's specifically limited in the statute to indigent defense services. And like you said, many other counties reported what they budgeted for their public defender. And the public defender does all these things. So how do we break it down to know how much time the public defender spent on a 432B and break that out of their maximum contribution or what they said that they've spent? And that's kind of the one flaw that we're facing, and we don't know how to get around that.
Thank you, FedEx. I appreciate that. That makes sense.
Ms. Reba, this is John Arascata. I have a suggestion on section 4 where discussing the death penalty, and you discuss the cost of providing indigent defense, including the cost related to an expert or investigator fees. I suggest deleting including the cost related to expert or investigative fees and have it state in accordance with the ABA guidelines for capital defense, because they go much further and beyond just the cost related to an expert or an investigator. A mitigation expert is a team of experts. It's just not one person. So I think you have it in accordance and compliance with the ABA guidelines regarding death penalty. Jonelle would have the exact name of it at the tip of her tongue, which I don't. I think that'd be an important point to have including in the cost.
That's a useful comment. And I would like just to make another, I want to make two comments and so then ask a question. So my comments are that it seems on the death penalty that we want to have, we're sort of thinking, and maybe one of our other commenters will remark on this, but it seems like there's sort of two issues that are distinct. One is access to high quality resources by the people who are doing the work in the defense work. And the other is who's footing the bill. And those seem to be kind of distinct issues, which is we want to be able to get resources immediately, quality resources to the people who need them in any case that's sort of going that route. But the question of who's footing the bill is where you get the perverse incentives possibly related to that. So I just want to sort of flag that as a problem that we maybe need to make sure gets solved in the language. But then I'm also just, I'm not sure where we are in, if I understand the proposal on having the state public defender continue to pay for appeals, but not absorb the full cost of death penalty. I'm not sure if I'm tracking the language change that you've proposed. Looking at the slide and listening to you, I'm not sure if I'm actually understanding the language. So if you could just like backtrack and say what that is, that would help me a lot on that one section.
So, and we didn't actually write any language out. This was a discussion that we had late yesterday, but a thought would be to separate subsection 4 into 2 sections.
Okay.
And, maybe start off of if a county chooses pursuant to section 21 to transfer the state public defender the responsibility of, and then maybe we could have subsection B, death penalty cases, the cost of providing indigent defense services. And then I think we could add, if the board is agreeable, Mr. Arascata's language of in accordance with the ABA guidelines for capital or death penalty cases, those charges or those fees must be a charge against the county to be up to the maximum county contribution. Something to that accord, or I don't know if you have other, and then we could have a subsection B of transfer of direct appeals to the Nevada State Public Defender would be at state expense and would be deducted.
Laura, this is Joni. I have a question about what you just said. And it was Laura, correct? Was that you, Laura?
I think it was Chairperson Trom.
Well, I made the comment, and then Executive Director Reba was just speaking about the proposed language. So.
Oh, I'm sorry. I got the voices confused. My apologies.
No
so my question is, when adding those death penalty costs, the comment was up to the maximum of the county's contribution. Is that in addition to what they've already budgeted? Is that an amount equal to the budgeted amount each year, or is it once we hit the max, whatever the county is budgeting? I'm confused about that part.
Ms. Reba, can you walk us through that?
And Ms. Easley, I think when we get into the plans, it kind of makes it a little more understandable what our department does, because what our goal is if we're able to pass these regulations, what we're hoping to do is sit down with each county and have them kind of write out what is their plan for indigent defense services. How are they going to be providing these things? How are they going to be complying with these standards? And when we sit down and try and determine what they're planning on doing, our department is also there to assist with the cost of estimating how much it would cost to do that. So once we have that cost of what the county's plan would be, we would have to apply the maximum contribution formula, which is still to be determined. And whatever the cost would be minus the maximum contribution would be the amount that we would request from the state on behalf of that county. And again, even though we are asking for this formula, ultimately it's up to the legislature to determine whether or not they agree with their formula and whether they're going to fund it. So even if
that's the scary part.
We have to get it through the legislature. So that's another point.
May I ask a question about Professor Trom brought it up, and it's just an ongoing as everybody's been providing their input. My understanding is the Clark County DA's office has a death penalty review process. John, I don't know if Washoe County has, the DA's office has some kind of monitoring to determine whether or not to charge the death penalty.
They put together a committee on cases that they want to consider for death or not. So they do, but it's not an ongoing standing committee, so to speak.
Okay, and in those experiences, and I'm asking, I think, John and Drew, to the extent you have any kind of an insight into those decision-making processes, I would assume the cost to the county of prosecuting and defending a death case would be a factor. Is that a fair assumption?
Absolutely.
Yeah, always make it a factor. It tends to fall on deaf ears.
Okay. Well, I'm not sure it does in Clark. Drew or John or Jeff?
Yeah, say that again, Laura, because you broke up a little bit.
Okay, I mean, I'm asking a bunch of questions, but the bottom line is, it is fair for everyone involved on every level, county, state, prosecution, defense, to consider, there may be cases that there's just no question it's a death case, but there are a lot of cases where there is discretion, and in the exercise of that discretion, the prosecutor should, or I would hope, consider, okay, this is going to cost, millions of dollars or, hundreds of thousands of dollars. And that's a factor, so we're not going to charge the death penalty. My concern is, and Marcy, I understand that with the caps, we're blunting the potential liability of a county. If it decides, okay, every murder is going to be a death penalty case, I'm not saying any county now will do this, because I would certainly hope they wouldn't. But if they're all charged as death cases, then, and the state takes all of the burden, and the public defender's office, you were saying, Marcy, takes on 2 new lawyers and mitigation, full-time positions, right? It just seems to me that that all through the system, from the charging decision through the trial decision, through all the economic impacts, there's no monitoring of, okay, why did you charge this as a death case? We don't have that authority, obviously, because that's a prosecutorial function. But I'm just worried going forward with the temporary regs and with your budget, our budget, that this is going to create a bunch of inflated things. I don't know at all what the legislature feels about the death penalty. This becomes a very complicated issue. If there was some method, to have a share, I will defend our caps to the death, because we've fought for them. We've promised the county that we will have caps, but I do think the county needs financial skin in the game before they make a death decision. So I'm quiet now, muting.
This is Chris. I think if the simplest thing would be we just get rid of the death penalty next session, but I'm just saying.
No.
Hey, Laura, this is Jeff. I agree with you all the way through except for one point. And that point is, in Clark, I really don't think our district attorney's office in general thinks about it at all, how much it costs. They look at the facts of the case, they make their prosecutorial decision, regardless of whether we think we can afford it or not.
And this, if I could comment, this is Darren Emley. I'm the public defender for Clark County. I would agree with what Jeff Wells just said. The big difference is there's not much cost difference to the prosecutor between a regular murder case or a capital case. The huge expense is in our office in defending the case, Jonelle's office in defending the case, because it does require the mitigation specialist, the 2 attorneys, and so the cost increases dramatically. So I do not think they take that into consideration, because it doesn't impact them the same as it does the defense.
Okay, well, obviously I'm going to defer to the people that actually know what they're talking about. It's just in terms of the budget and the requirement of cutting budgets and all that stuff. Okay, well, it's something to think about. You all have been thinking about it.
I would just, this is Ann Trom. I would just suggest a slightly different frame for thinking about this, which is, I think it's correct that if the state absorbs 100% of this and takes it off the shoulders of the county, that is probably a perverse incentive in the way that people have noted. And if it's subject to the regular formula with the maximum controls, that doesn't completely alleviate the problem. It just sort of changes the calculus. And I'm not sure that we have sort of authority to do much more. But one other way to think about it would be to build something in that triggers an assessment of the total cost so that that can actually be calculated or considered as the case arises, right? So that there's at least an assessment of costs. That might be just even that moment of studying and assessing might be something that the department does have some authority to do, and could inject that calculation into the process, or at least make it sort of public in a way that might be potentially useful. So just an idea. Okay, I'm curious about other comments and whether we should be pausing to hear more as just specific to 18, which seems pretty consequential, before we move on to like 19, 20, 21. Ms. Reba,
This is Jonelle Thomas. I submitted some comments in writing it, and yesterday Marcy and her team were very generous to meet with the 4 institutional defenders and to talk out some ideas. One of the things that we thought might be a possibility, those who have been around for a long time might remember Michael Pachetta's habeas resource council job. I think it was back in the late 80s, early 90s. Yeah. And possibly providing something similar where the state PD's office could provide expert and investigative assistance, referrals, if you would, help with brief banks and case strategy meetings, and not take on full responsibility for the case, but be a resource to the people in the rural communities. And certainly the institutional defenders are happy to help with that. I actually think the costs are going to be greater for rural communities who are seeking the death penalty. I seriously doubt that they have the high quality MRI machines that we're now using to analyze brain trauma in a death penalty case. So dealing with the transportation of a client from the middle of the state to one of those facilities, it has got to be a costly endeavor. I think it becomes really complicated. I agree. Ultimately, the answer here is to get the legislature to realize that the expense of the death penalty, all other issues aside, is something we just can't afford. But I think there are some alternatives where the state could give assistance other than directly taking over all of those cases. Thank you.
Thank you. Ms. Reba, do you want to go on to the other sections?
The only point that I didn't know if we could get any further discussion, was trying to figure out that average of the fiscal year 18 and 19, how that's kind of an impossibility for the rurals. We haven't touched upon that. You know, and reaching out to other jurisdictions, Texas Indigent Defense Commission, once they find what the cost would be, they pay 10% of the costs, and that would be allocated to their state. However, if the county forms an organized public defender office, they pay 30% of the cost. So it gives an incentive for the creation of a public defender's office. That's something that they felt has worked in Texas. In Idaho, or actually in Michigan, I believe they're given a set amount from the legislature, and then counties submit their plans, and then they divvy it up in accordance with the priority of the plan. But we weren't able to find necessarily a maximum contribution formula, which would fit within our statute for guidance. Most of them are either given a set amount by the legislature and they distribute it, or they provide a percentage of the cost. So I don't know if that would be an alternative, or if anyone has any guidance of how we should guide the rural counties in determining these costs, or if they're happy with the formula as is.
If people want to weigh in, I think I'd love to hear from the counties, or Drew or Jeff, on your thoughts about that.
Well, I think consistent with the statute, I think what Marcy's already written in section 18, paragraphs 1 and 2, et cetera. I mean, I think that is consistent with the statute that was passed, and I think that basic formula is fine. I recognize that we have some level of difficulty of actually calculating what that dollar amount is, but as we move forward, it will self-adjust simply because of the inflation in the COLAs for the union costs. And so over time, that formula is going to work, even though it's slightly difficult right now. However, that doesn't solve the problem we've just been spending the last, 20 minutes on talking about paragraph 4.
Chair Trom?
Yes, of course. Go ahead.
Dave Mendiola. Yeah, I agree with Jeff. That's kind of what I was thinking. In the end, we could sit here and hash this out forever and come up with 100 different reasons that we need to break it down. But bottom line is we're really gonna have to live and learn this process here and make adjustments as we go, in my opinion, just like we do with all of our budgets. So this is kind of a new world. So yeah, I would agree with Jeff's comments, but you're right. We kind of got to fix that section 4 there, subsection 4.
I just wanted to know, is there a need for language to make adjustments that either might take in things that don't get counted or, don't get counted or weren't counted? I mean, in order to make a showing that they were expenses or should have been expenses and that's going to affect the number. Is there a need for that kind of language, or do you feel like there's going to be enough give in what's proposed to do that, to get people where they get the counties where they need to be?
Dave Mendiola again. I would like to think and believe that as we go down the road and we find that there's disparity in the current rulemaking, that the legislature will take that into consideration and will adjust that. So if we find that we were under budgeted because of some factor or factors, that they would relook at that again and then budget it correctly, so that, again, while trying to meet the requirements of the lawsuit and the resolution out of the lawsuit, that they're going to have to step up and do some things to meet those requirements, and it shouldn't fall on the counties. So I would hope that.
I agree.
Okay, that sounds good. And this is another reason why, if to the extent we're having temporary regulations, this is a place where we could fine tune in the future and stick in language that is exactly what we need to give to get people get the counties where they need to be. Okay.
Madam Chair.
Yes.
This is Bevan Lister.
Thank you.
And I appreciate Marcy's investigation into what other states have done and the way that they address it. One of my, I guess, questions would be is how many of those counties in Texas or Michigan have less than 2% of their land in private where they can assess taxes on it? It has a significant impact.
That's a great point, Bevan.
Mr. Lister, we do not have a direct answer to your question. We can reach out to the Texas Indigent Defense Commission and get that. I do know that the Texas Indigent Defense Commission has, I think, over 150 counties that they're in charge of running. So they have a significant amount. And in talking to them, they have transitioned some of those counties into the organized public defender offices. But I think, that's a pretty big state. So we can reach out to Texas and see if we can get that answer.
No, I appreciate that.
Marcy, this is
what you're going to find is that none of the counties in the rest of the union, except possibly Alaska, have as low percentage of private land in them as the rural counties in Nevada. So it's kind of what I'm just saying is we can't compare apples to oranges. The budgeting constraints on our rural counties is huge, and I'll just leave it at that.
This is Lorinda. Marcy, I'd like to add that when you're looking at Texas, you'll find that they have no public land. It's all in private ownership.
Let's get back to the issue of what we're discussing, which is the death penalty administration part. The whole point was it's about people's rights for justice, not about lands. So let's move on.
So I think those are really useful comments. And I think one of the things that I found interesting about Marcy's comment was just that we have in our regulations a maximum contribution from the state. But I think one feature she's describing from Texas, which is kind of interesting, is just a more generous contribution from the state that would actually be beneficial to counties, sort of based on policy goals. Like if it makes more, if you deliver better indigent defense, the state could possibly be more generous. And so the counties would actually be shouldering less of a burden if it kind of went those routes. So I think, I'm not sure that's something we need to pursue. It's just kind of an interesting thing that we could maybe keep our eyes on in the future. So,
Anne?
Yeah.
This is Jeff again. I'm still thinking about paragraph 4 and whether that really creates an incentive or not to charge the death penalty. What if we, and I don't care the percentage, it's kind of an out of the box thought, but what if we just say that the county is still responsible for 25% of that cost up to the maximum as established in the first part of section 18. That way they have a little bit of skin in the game, and maybe that'll lower the disincentive a little bit to shift it off and charge death penalty. I don't know. I'm just looking at something as a sort of a quick compromise on that topic.
Mm-hmm.
Or maybe it's 50%. I mean, I don't know what the right answer is.
And Madam Chair and Mr. Wells, if we do look at 18-1A1, it does call for the average of fiscal year 18 and 19 minus any expenses related to murder and capital offense. So I don't know if by creating that formula, we're already saying that capital would be a state expense or not, but that language is in there that they're supposed to subtract that from the information they provide to us.
But that's just how you get the base so they can start seeking reimbursement under 19. They might already be under, for example, the formula for this particular year and still have room to pay some of that expense. And then you move forward. That subtraction right there was just to make sure that's not a subtraction for the future. It's a subtraction to make sure that the base year for the formula did not have a capital case in it, so that they had an artificially high base. So once that formula amount is established for those two average, that dollar amount is what moves forward. You don't do the subtraction year after year. It's just subtracted once to establish the base dollar amount.
So, and I guess one of your other proposal, the idea that that the county commits to a certain chunk of change, sort of as long as it's within the maximum, that sort of anticipates a scenario where it's it's fiscal year day 1, right, of the fiscal year, and they've got a death penalty case, which is going to eat up a big portion of what they've allotted for the year, and they might sort of then think twice about whether that makes sense for them, because it might blow a big part of their budget. That's sort of your thinking on that, right?
Yep.
Okay. Any comments on that proposal from Mr. Wells?
I think it's a great proposal. This is Laura Fitzsimmons.
Any comment on the number that gets put into that, the percentage commitment that gets put into that proposal?
Maybe start with 50% and then see what objections there might be or how that would play out. If you go too low, there won't be an incentive. So.
And is that Chris G speaking?
Yeah, sorry. Yes.
Okay, that's all right.
This is Julie Kavanaugh, Bill.
Yes, go ahead.
I think you said before, Marcy, that Texas uses a 10%.
That was a different issue. That was on the establishment of an incentive that the state would shoulder, I think 30%, or no, that the contribution of the counties would be lower if there was a public defender, institutional public defender set up. So as a way of incentivizing. But not
because I understand, I think that was Joni that said, start at 15% and then see if we get comments. But I don't know if there's been any kind of study or something done in terms of what percentage is bearable. I just hate to throw numbers out without having any backup information as to where we're getting those percentages.
I think the main percentage in terms of what the county shoulders is the maximum cap on their contribution. And what we're talking about is what Mr. Wells is proposing is to just create a percentage on death penalty cases that wouldn't change their overall maximum for the year, but would shine a light on the sort of financial commitment of a death penalty case that that would make them, think about that. It wouldn't change their overall contribution for the year. Is that
okay? That makes sense.
Correct, Mr. Wells?
Yeah, no,
Thank
that's exactly what I was thinking, and I just soon on the percentage defer to whatever Joni or Dave or Lucinda recommend. They come from that group of counties. Whatever the three of them come up with, I agree to.
Madam Chair, Dave Mendiola.
Yes.
I think, again, going back to the discussion of the actual costs, as the Clark County folks and Washoe County folks know, even a 25% buy-in is a big number for the counties, huge number. 50% is completely unreasonable. And again, I think in the end, to me, I think going back to what Marcy mentioned about the Sixth Amendment Group's report, is that our job, our goal is to give the very best representation we can to our clients. And if that's the case, that's for the rurals. Most of the time, that's going to be some kind of combination of the state and the local public defender and or the state as a whole. So quite frankly, I think the burden should go on the state. And so 25% is
absolutely.
Mr. Mendiola, I just kind of didn't hear the very last phrase.
Right.
So if you could just repeat the last sentence that you said.
You're asking an old guy like me to remember what I said 5 minutes ago. That's a difficult.
The percentage that you said.
You said 25% is, and then somebody else cut in.
Yeah, I said 25% is reasonable. Regarding skin in the game, I agree with that. But 50% is terribly unreasonable.
That makes sense. Is everybody comfortable with that?
And Chairman, this is Drew.
Go ahead.
Just real quick, I'll support, Commissioner Mendola and the other rules as to what the percentage should be. But bear in mind, the concept of what we're talking about is if, in fact, let's say a rural county filed the death penalty, and whether the number's 25, 50, whatever it is, then we're asking the state to support that other amount. Ultimately, one of our goals is to have the state supply amounts for just the general delivery of criminal defense. And so I don't want to create an incentive where the state just supports capital defense. I think our bigger goal is to have the state support for the counties, just the general delivery of defense is that what we would like. So I agree, and I'll support the rural's number, but a higher number for the county, I think, would answer the questions of they would be less inclined to file capital. And if the formula suggests they need more money for just the general defense delivery, I'm much more comfortable for the states to help the counties on just the day-to-day operations than on a capital case. That makes sense. And so, but I'll support the number that Mendiola and Lucinda and everybody else comes up with, but I just don't want it to backfire where the state's now supporting capital, which in one sense is great, but I think the whole goal of this was have the state support the counties just on their day-to-day operations and hope that there's not much capital that comes forward, because as they previously said, there was $500,000 potentially for that case. We pay that all the time. We have 80 cases in our system here in Clark County between the private bar and the two institutional offices. And I just don't want to see that start proliferating. Jonelle made a good comment that the reality is of our death penalty statutes, that pretty much any murder that takes place or alleged to take place, you can find an aggravating factor where they could potentially charge death. And so, you know, that ferment of narrowing the cases that charge death really doesn't exist anymore. And if we could provide a financial disincentive for the counties to file, I think all the better for us. And if we catch money from the state, let's catch it on that day-to-day operation rather than the one case here and there.
I'm seeing Lorinda, I'm seeing your hand. Ms. Wickman, do you want to, is your hand
Yes.
up? Please go ahead.
Yes, it is. I just wanted to add that I agreed with Jeff in the beginning of this conversation when he said that our intent, or what happens in our public defender's office, is they simply don't pay attention to the budget. They do what they're required to do to defend cases that are brought forward by the prosecutors. So a conversation about money is something that's going to have to take place on an administrative scale. Is there any way to put language in there that would allow this group, our DIDS board, to review cases that come up like that and establish what the appropriate money is at the time, so that we get to review it throughout the year rather than having a set of rules that we have to follow and we're not even sure what's going to come up in the future? And the comment that was made about Texas is absolutely directly related to this. When you're talking about money, you're talking about where does our money come from? When Nye County is 96% federally controlled lands, you absolutely have to consider where your money is coming from. So can we keep our eyes on how we provide the defense to the people who need it and put in language so that it comes back to this board for review and help when there's an unusual situation of any kind? Thank you for taking my comments.
Thank you. So one response I have to what Ms. Mickman just said, and some of the other comments is, I do think that it's really important that the state obviously is going to be on the hook at the final accounting, and the county contribution is going to be capped. But I also think it would, so this idea that I suggested earlier, I do think might be useful, which is it would be useful to have some language in here that the costs would be estimated, because I think even quantifying the amount would be a useful exercise. If for no other reason than just to have a record that we looked at this case and sent it to an expert to kind of work it up what the total cost would be, no matter who's paying for it. And I don't think in the end of the day, it's going to shift from the state's going to absorb whatever's over the max. But that might be a useful thing that we're tracking in terms of just this issue, right? That maybe isn't actually being calculated now, right?
I agree.
And I agree with Lorinda's comments. You know, we don't now, and everybody's comments, we're throwing out percentages, we're throwing out numbers. This may be one of the good instances, as Marcy indicated, of having temporary regs. But we have to, you know, on behalf of the state, we do have to see, and we can't decide today, what works so that, because we're assuming a massive liability on the part of the state, taking some of it off the part of the rurals, which we want to do. But let's see what we're talking about, because it may be in the future. And I think this follows up on what Lorinda was saying. We do have to get a mechanism to start addressing the charging decision with the rurals individually. We may or we may not, but I think it's too soon to tell what the impact's going to be. But I do think if the rural charging decision realizes that we are looking at what they're doing, if all of a sudden we see, you know, 5 death cases coming up, and, you know, historically there's no basis, I mean, that's just a huge spike. You know, we do have to find a way to make sure that we're not just opening the state purse for every death case as Drew said, every homicide to be charged as a death case, because obviously that will drain the state budget.
Okay, so where are we with? Go
hello?
ahead. Please go ahead, Mr. Arcetta.
This is Bill Moppin. This is just an editorial comment. The more you require the state legislature to analyze its budget based upon the death penalty, the closer you're going to come to having it repealed. For one thing, every year, part of the Supreme Court's base budget and then enhancements to base involve funding of a portion of the central legal staff called the death penalty department. And that is where a huge amount of the Supreme Court's general operating budget is committed. What I'm saying is when you end up with the legislature having to continually spend these kinds of monies, it's going to finally work against the incentive of district attorneys to charge death penalty cases, as Drew points out, because the political imperatives that have gone into the death penalty cases have it that you can charge almost any murder as a death penalty case. There's only been one case that's come down that has narrowed the scope of the death penalty, and that had to do with felony murder prosecutions years ago. So anyway, that's my comment. Also, I'd like the record to reflect that I signed on at 9:30 and I will have to get off at 11. But thank you.
Thank you, Justice Muffin.
And
Madam Chair.
Yeah, I'm hearing Jeff Wells and somebody else, maybe Julie Kavanaugh-Bill. I'm not sure.
Yes.
Yeah, please go ahead, Ms. Kavanaugh-Bill.
Thank you. So the other factor we've got to look at, we're talking about, is this going to increase charging decisions? You know, the state can cover it, but like here in Elko, we hadn't had any open murders for years, and we've had 4 this year. So there could be circumstances that are that it's not that the DA's office is wanting to charge these, but you know, it's going to depend on the crimes that are being committed as well. So I just wanted to put that out there.
Okay, and Mr. Wells, can I hear from Mr. Arascata first, because I think he's had his hand up.
Sure.
I apologize.
Yeah.
Go ahead, Mr. Arascata.
Yeah, thank you, John Arascata, Washoe County Public Defender. I'm following up on Ms. Fitzsimmons' comments of having some concept of the costs, and that was one of the reasons why I suggested adding in including the cost as related in accordance with the ABA guidelines on capital defense, because those won't give you the actual costs, but it'll show you the work that's entailed that goes in, and then you can talk to the experts that are needed in each specific case and be able to come up with a fairly good idea of what the costs of that particular case will entail based on its specifics.
Okay, thank you. I'm going to go to Mr. Wells now.
So in an effort so we can move beyond Section 18, I'm going to attempt to make a proposal that I think gathers up lots of people's comments. My suggestion is we're going to split paragraph 4 into 2 parts, so we leave the appellate process, because that doesn't seem to be the debate, and we'll make that burden on that go to the state. On the other part, and again, we're only dealing with counties under 100,000 in this paragraph 4. And so for the second part, I want to take Lorinda's comment, because I don't think they occur that often, and that when they do occur, that it'll come back to this board for our decision on how much the skin in the game would be for that rural county, up to subject to their max that we already have established, but that we can't go higher than the 25% using the number that came from Dave. The interesting part about that is it helps, even though it's a smaller percentage, it might dissuade somebody who had the incentive to try to push it off to the state simply because they don't know whether we're going to tell them their contribution is 0%, 10%, or 25%. And I'm trying to merge everybody's comments into one thought.
Madam Chair Trom, if we could just add one thing. Presently, the Nevada State Public Defender is not staffed to handle death penalty cases. So if counties do accept this to opt into the appellate and into the death penalty coverage, we would have to request additional staffing for her office. So I don't know if there'd be a problem with requesting that additional staffing from the legislature if there wasn't a set expected number that the counties would be required to pay. And at this point, like I said, presently she doesn't have the staff to be able to cover these things. So this would also be dependent upon the legislature's approval of our maximum contribution formula.
Okay. I guess one of the concerns that I have related to Mr. Erscott referenced this idea of costs in accordance with the ABA, but there's no timing mechanism here to kind of figure out what those are. And if this happened tomorrow, right, before there was approval of new positions or whatever, if we're even seeking that, there's no, how would the, so I guess one question is just to quantify the cost. There's no triggering timing mechanism. And I think it would be useful to have some kind of triggering timing mechanisms to figure out the costs, maybe within X number of days of the charging decision. I don't know. You know, to get an estimate. But also, I'm just curious, if there's no staff in the public defender's office, in the state public defender's office to do this, how do you get the right resources to the counties? Can you?
So what we would have to do is, if this regulation passed, we would, counties would have the opportunity to opt in to representation for the public defender, and they have to let the public defender know before March 1st. If they let her know before that date, we would modify our budget to request the staffing appropriate for all those counties that have opted in. So ultimately, there is a timing mechanism in that this representation would not begin until July 1st.
Okay. And I guess my comment was just on the timing mechanism in any specific case, which is it would be useful to have a calculation of costs close in time to the charging decision, so that there was at least sort of public information both to the counties and the state and the prosecutor and the county commission that like what the total would be. And I think that would be useful for the legislative process as well going forward. Any other comments on?
I have one comment. This is Ms. Kavanaugh.
Go ahead, please.
So one thing we have to keep in mind, and you know, in listening to Jeff and Lorinda's comments, and Madam Chair, your comments about timing. My thought on timing is I wouldn't want anything that the county has to provide to us in terms of estimate of costs and things like that. I wouldn't want there to be a lapse in time for the defendant. So we're adding processes, but I would want to make sure, because in our standards, our proposed standards, we also are, you know, instructing the public defenders in terms of how much time to meet with the client, to get that first hearing, those types of things. So I would just want us to be cautious about adding more on top of that. I wouldn't want the defendants to have to wait for decisions of the board in terms of what the approximate costs are if they're going to use the state public defender's office.
Can I go to Jonelle Thomas, who has her hand up next, before I come back to you?
If I can just say, it would have to be subject to an amendment, because early on in the case, it's doubtful that you're going to have the knowledge of the client's background and family history and just a huge amount of information that becomes necessary for making decisions down the road. Knowing, you know, is out of country travel going to be required is often not known within the first month of representation. And so I would definitely encourage an amendment process.
Okay. Mr. Wells, did you have a comment? I wasn't sure.
Well, Marcy's comment about the funding is correct, but even if we don't change a single word to paragraph 4 the way it is, we still have that funding issue to the extent that any of the counties under section 21 decide to transfer the death penalty cases. And so the only difference is the way it's written under section 21 is they sort of do it ahead of time, not knowing if they're going to have a death penalty case. And I thought the only way we would be able to get rid of the argument that the public defenders have presented to us that there might be an incentive is to almost tie it to a case-by-case basis as it moves forward. And so, but the staffing requirement for the state public defender's office is true just the way it's written right in front of us right now.
Right. Right. Okay. I guess we're sort of at a little bit of a procedural juncture, which is, I'm not sure that we're like sort of voting on this as a board. I think we're working through these regulation proposals. So I don't want to sort of take action for that, but I do want to, I think that Mr. Wells made a very useful suggestion on language that sort of accepted the idea of breaking section 4 into 2 parts, adding Mr. Arascotta's concern about ABA standards, and then adding the idea of the percentage. I'm seeing another hand from Ms. Wickman, and then maybe we'll take this and move on. So Ms. Wickman, go ahead.
Yeah, I just have a brief comment. If we would just advertise what these are when we're done with them, it would tell those people who are going to be perpetrators into the future that prosecution has all the money it needs, but defense is going to be limited. So please don't do any capital murder cases.
If I can just add, I promise you my clients are not reading regulations. They're making a decision about whether to commit a crime. So in theory, I understand the argument, but in reality, that's not a thing.
Okay. So I think, are there more comments?
Actually,
Go ahead.
That was my point, because they're not reading this. The offenders are not reading this. And I guarantee you that the people we have online that are from the public defender's office are probably the only ones that take the time to look at what the budget problems are going on. In the rural areas, they do not. They pay attention to their jobs regardless of what their budget is. They just do their jobs. Thank you. I'll silence myself.
Okay, so I think that we've had a full discussion on section 18, which is a really important section. I think we have useful suggestions. Ms. Reba, do you have anything else that you feel is sort of needing attention here, or do you feel like we can move on to 19 and the others?
No, I feel we can move on.
Okay, thank you. Please go.
So with 19 and 20, we kind of wanted to make the process or an explanation that once we figure out what the maximum contribution formula is, how does it really work? And in 19, this is kind of the procedure for determining costs. And this was basically missing before. So there's 2 ways that counties are able to get funds through our request to the state legislature. The first is when they submit their annual report, which contains the plan for the provision of indigent defense services and that estimation of costs. Then we apply that maximum contribution formula and we add that into our budget to request on behalf of the county. The second is if they go through their maximum contribution and then they go over that estimated amount of what we thought and they're looking like they need more money, the other way that we can go is through the interim finance committee, but we have to enter into a corrective action plan. So it kind of clarifies that portion. We are asking to delete subsection 2, the red portion, because it was just surplus language. And that takes us to the next page that says, you know, when we're talking with these counties and we're creating these plans and we're sitting down and figuring out the budget for them, if there are any disagreements, what we'd like to do is be able to bring it to the board and have the board ultimately decide what is the appropriate amount that we should be asking for on behalf of this county. So we wanted to clarify that. And then we're also asking that counties seeking reimbursement pursuant to section 18 submit us quarterly financial status reports for how much they've spent on indigent defense, so that we can keep track of how close they are to their maximum contribution, and we can start determining if they're going to go over that estimated amount and start talking to the counties of, do we have to enter into a corrective action plan? Do we need to go to IFC? And that'll just help us keep a better hold on how much money is being spent for budgeting purposes. So we are asking for quarterly reports. I don't know if there's any comments on that.
Marcy, this is just a quick technical 2-second thing. Paragraph 3 there of section 19 says a county seeking reimbursement pursuant to section 18. Section 18 just actually establishes the cap. The reimbursement's in paragraph 1 of section 19 where it says they're seeking the reimbursement. I think the reference might be slightly off is all.
We can fix that. Thank you.
And this is Julie.
Go ahead, please.
Julie Kavanaugh. And so, Marcy, you said that we're striking paragraph 2, and you said it was surplus language. Is that because you believe that in paragraph 1, the quote provision of Indigent Defense Services unquote covers everything already contained in that paragraph 2?
Yes. Yes.
Okay. Thanks.
Other comments? Oh, Janelle Thomas, I see. Looks like your hand is up. Is Ms. Thomas?
Apologize, that was a mistake.
Oh, that's okay. Thank you. And Bevan Lister?
Thank you, Madam Chair. So here, and it seems like in a couple other spots, it refers to a form approved by the department. Are those forms already available? Are they yet to be created?
Well, at this point in time, we have not necessarily created a form. We did do a financial reporting form for a yearly reporting form, but we haven't done this quarterly reporting form because we didn't know if it'd be needed yet. However, if the board recalls, we do have a data analyst, and one of the things we're able to retain him for is to assist us with creating these forms. So once these regulations move forward, if that's approved, we can start working on these forms.
Thank you.
Okay, other comments on section 19?
Chairman Trump, Dave Mendiola. Marcy, I would just recommend that, again, and I'm fine with the quarterly reports. I'll just speak for Humboldt County. It's all computerized, so it'd be very easy to do. I would want them all to be the same though. Unless you're looking for just some key information on the quarterly, in our system, I want one button we push for one report. And that's a lot easier to do. Now, other people who have to do it by hand, if they're still doing it that way, which I doubt it, but if they are, that might be an issue for them. So maybe there is a shorter form to do for the quarterly report, but it would be great if we could just have one report and we do it on a quarterly basis.
Okay, anything else on section 19? Maybe we'll move on to section 20. Oh, wait. Mr. Lister, do you still have your hand up, or I'm not sure if is it a fresh hand or?
No.
Okay. Okay, great. So, Ms. Reba, section 20.
So section 20 follows section 19, just clarifying that any state contribution is for one fiscal year period only, and it's for the express purpose of indigent defense services. So it can't be used for the prosecution or anything other than indigent defense services. And it kind of discusses that reimbursement process through that quarterly fiscal reporting and what to do if that money is exceeded, how we would have to go to the interim finance committee to request additional funds. And then ultimately any unencumbered or any unexpended balance of that state contribution on behalf of that county would go back to the general fund on the end of the fiscal year when all the reporting is closed.
Comments on section 20, or can we move on to section 21? Why don't you move on to section 21?
Section 21 clarifies the request of a county with a population less than 100,000, how they can request the services of the public defender to handle the death penalty and or direct appeals. And it expresses the process where if they wish to have the public defender, they have to give notice to the public defender. And it also expresses how to transfer back to the county if the county would like to take back those appeals or death penalty cases. And that's specifically set forth in NRS 180.460. So we felt that that was the best way to handle reverting those duties.
Mr. Arascata, do you have a comment?
More a question than a comment regarding 18, 19, and 20. Our budgets are set by our county commissioners, and when we have a need for, say, additional budget due to unforeseen circumstances, we go to our counties. So I'm assuming that 18, 19, 20 do not apply to counties with population over 100,000. Is that accurate?
The intent is that anyone that is seeking reimbursement from the county for the county's portion that's determined for the maximum contribution formula would be submitting quarterly reports. So yes, Washoe and Clark would be included if they're intending on requesting part of that maximum contribution formula.
Only if we're requesting aid from the state.
Yes, I believe so.
So if I have a budget issue and I go to my county commission and they provide the funds that are needed, that's the end of the issue. We're not having to have our budget be with the Department of Indigent Defense and then having to go hopscotch up to the Department of Indigent Defense. We only deal that. So 18, 19, 20 apply only to counties with population under 100,000.
Intent is that this form is to be certified by the Board of County Commissioners or its designee. So it wouldn't necessarily be each public defender submitting their financial forms to our department. It would be one form from each county's Board of Commissioners or their designee.
John, this is Jeff. The way I read it, at the moment, 18 actually has a Part A for under 100,000 and a Part B for over the 100,000, but you would not trigger sections 19 or 20 unless you were seeking money from the state. So most likely both Clark and Washoe would do exactly what you just said. They would go back to the Board of County Commissioners. Therefore, they would not trigger 19 and 20, and 21 by its own language is only limited to under 100,000. But 18 itself technically has both provisions in it.
Thank you. That answers my question, Jeff. Thank you.
Okay.
Go
ahead,
Kavanaugh.
Please go ahead.
Thank you, Madam Chair. My question, so in section 21, it specifically says all death penalty cases and or direct appeals. So, and then section, earlier when section 18 just said, basically if they take death penalty cases or direct appeals. So are we saying that the county has to make a choice that they're going to transfer any and all death penalty cases in a given year and any and all appellate direct appeals? Or is it case by case basis?
I can answer that, Madam Chair. The answer to that would be that this would be all appeals and or all death penalty cases. The reason for that is for budget building purpose. We would need to know whether the counties are opting in by the deadline set forth in the statute so that we could build the budget to go to the legislature. So this isn't an in and out sort of situation. And once the counties have decided they want the public defender to handle the cases, if they'd like that to be transferred back, they have to follow the process set forth in NRS 180.460.
Madam Chair, can I follow up on that?
Please, go ahead.
Okay, so the concern I would have, say a county hasn't had a death penalty case in 20 years, and they get one in June. So they didn't make the March 1st deadline to opt in. Are we gonna, is there some way they can is there an exception to that? Or I'm just, if in that situation, we may have a county that's, just does not have the funding or the, the resources to handle a death penalty case, what would they do?
I think the answer to that would be no, you cannot opt in. I think the opt-in timelines are set forth to opt in to the representation by the public defender that's set forth in statute. So I think that if there was a death penalty case and there was no opt-in, it'd be subject to the maximum contribution formula.
I guess I have a question on that, which is, I think it's an interesting point, and part of it is, I think the overall goal is to really support indigent defense in the best way possible wherever it's happening. So to me, the same situation could arise with a regular appeal, which is it just seems to require additional help. And is there a mechanism, even if the funding mechanism is set, is there a mechanism to just get the resources needed to the case by case as it comes up, so that just that level of support there's infrastructure for that level of support, I guess is my question.
I think the question would be building up the Nevada State Public Defender's Office. If we don't have the people saying that they're going to opt in when we go in front of the legislature, they're not going to, I would highly doubt they would fund things just in case they happen or just in case things need to be transferred later on. So I think that we might have a problem with getting funding.
This is Julie again, if I may, Madam Chair.
Yes, please go ahead.
Doesn't Section 19 cover this though?
Ms. Reba, what do you think of that?
Which portion of Section 19?
Or maybe Ms. Bill,
Yeah.
Ms. Kavanaugh, can you just say a little bit more?
Yeah, if a county, so they didn't anticipate, say, a direct appeal, and so one comes in after their deadline to opt in, and Madam Chair, you were talking about, somehow having additional resources or things. So wouldn't Section 19 cover that if they went over their maximum contribution? Couldn't they submit and request that additional assistance?
Yes, we could go to the interim finance committee once the maximum estimate over is exceeded, but the public defender's office wouldn't necessarily have the staff to come and cover the case. It would have to be someone, in Elko or whatever the hypothetical place would be.
Okay, thank you.
And I guess my comment is just a little bit different, which is, if this happened, I would want to make sure that resources are flowing to the case as needed to provide indigent defense. And it might be that in the following year, the county would think like, okay, well, next year we're going to do this because it's like actually worth our while and we're getting the coverage that we need. But I guess it just seems like they're like having, I realize it's a budgeting issue, but just having the advice and support from people and the experts who know what they're doing on specific issues might be a useful process, because these things might come up, right? And they might be one-offs that don't merit even a visit to interim finance, but actually just get people the resources and the help that they need. I think that would be useful to figure, to have some place where practitioners can go to just tap those resources. Okay, any other comments on section 19, 20, 21? I think are we good on that? It looks like I have some hands raised, but if you can figure out on how to unraise your hand, that's just useful for me, because then I can tell what's current. Okay, so Ms. Reba, are we at the end? We're at the end of our sort of second chunk here, and could move on to 22 through 26B. I'm happy to move on. Is the sense of people that we need like a brief break, like a couple minutes, or can we just push on? Okay, let's push on with 22 and 26B. And is this Jared Hickman now?
Yes, thank you, Madam Chair.
Go ahead.
So sections 22 through 26B describe procedure for making and submitting plans for the provision of indigent defense services. AB 81 made changes to Chapter 260 requiring annual submission of plans for the provision of indigent defense services, but did not provide what those plans are or what should be in them. Chapter 180, as we know, generally provides authority for the board to fashion minimum standards to ensure that the delivery of indigent defense services meet constitutional requirements and don't impair the ability of the attorney to provide effective representation. To that end, I think Ms. Reba's reference back to the Sixth Amendment report and its recommendations are useful because that kind of provides an outline of these next few sections. And that are that the state of Nevada should authorize the Office of Indigent Defense Services to promulgate standards, including but not limited to attorney qualifications, attorney training, early appointment of counsel, attorney supervision, attorney workload, uniform data collection and reporting, and contracting. So with that, we'll start with section 22. This section is essentially the procedure for the initial submission. In paragraph 1, the changes there reflect the changes to the definition in section 10, and that is just the plan for indigent defense services should follow or be consistent with these regulations, and then removes the limiting language that was in A, B, and C. Changes to subsection 2 return the date of submission back to the statutory date. In the LCB draft, the June 15th date was inconsistent with the statute that I think 260070. We're trying to provide time, approximately 6 months to get an initial plan in. So if we're in the circumstance where the regulations become effective April 1st, and the statutory date for submission of the plan is May 1st. We want to be able to provide time to work through and get plans submitted by county without a 30-day drop dead date. The last addition to that, paragraph 2, provides some notification requirements if a county would like assistance from the department in creating its plan, to give us at least 90 days notice so we can plan accordingly and provide that assistance. The additions of subsection 3 and 4 are new material. Subsection 3 suggests that counties meet with their local providers to provide input when creating a plan. And then 4 gives direction to any grouping of counties that elects to create a multi-county office of the public defender, rather than submit individual county plans. One single plan encompassing all counties may suffice in that particular instance.
Okay, comments on that?
I actually have a short comment on 22 at the beginning. You struck, Jared, that the plan you struck follow the model plan approved by the board, but you left in submitted on a form approved by the board, which is essentially the same thing. To me, there's not going to ever be one size fits. I'd rather strike and get rid of the form approved by the board as well. The topics should all be included, but I'm going to guess that Clark County's plan and Esmeralda's plan might be different.
Thank you. Yeah, and that is a good comment, and we will strike that. I mean, the intent here was some of the feedback that we got several months ago when we provided the board with kind of a rough draft of what a model plan may look like, was that it was very, very confusing. So the intent here was just to create the contents of the plan via the regulation, and not so much provide the model plan that we initially struck out to complete. And then yes, with respect to Clark County, and those would be a little bit different. Yes, I agree.
Mr. Picker, did you have a comment? I saw your hand up.
I did. Thank you. The concern I have is that we already, both Clark and Washoe, have done plans according to ADKT 411 that have been approved by the Supreme Court. So my concern is that the way Section 22 is written right now doesn't seem to acknowledge the fact that we're already in compliance, and it doesn't, because it doesn't exclude counties over 100,000. And we were already required to do that, and our plans have already been approved by the Supreme Court. So I think there needs to be that language in Section 22, is that for counties under 100,000. Otherwise, you're asking us to reinvent the wheel. Thank you.
Response?
So we had kicked that around in our conversations last night, Mr. Picker, and again, thanks for meeting with us. I don't think we disagree with the idea that the Clark and Washoe model plans would not be sufficient. I guess what we went back and looked at after we had our conversation was that 260.070 requires annual submission of the plan. So I mean, maybe the language is to clarify that the plan used in approved in ADKT 411 would work as the county's annual submission.
I would agree with that line. I think that solves Clark's and Washoe's issue, and the issue that I think was raised by Mr. Picker and Janelle and everybody else.
Okay, other comments, or can we move on? Go ahead, Mr. Hickman.
Thank you. Just one moment while I finish a note. Thank you. Section 23 is a provision related to independence of defense function. This section, as you can see, the recommendation is to remove a large portion of language and just include the general principle in paragraph 1. I will note that the concepts or the ideas in paragraphs B, C, and in paragraph 2 are not removed from the revision so much as they were revised and relocated into sections where they made more sense. Some of the commentary that we received was that they were confusing and appeared to, I guess, interfere or wade into judicial provinces. So we revised those and moved those to different sections, which we'll get to momentarily. The only other change to the general standard or concept in paragraph 1 is to eliminate guarantee in favor of the word promote. Some of the conversations we had with judges indicated that promote might be a better term because, given the existing statutes in Chapter 7, guarantee may be inconsistent with those provisions.
Okay. Any comments on 23?
This is Julie Kavanaugh.
Go ahead, please.
So I appreciate the changes in the language I was reading forward, but I think looking quickly at these, it does address some of the concerns that I was receiving out here in the rules too, by the judges. So thank you.
Okay. I think we can push on, Mr. Hickman. Go ahead.
Thank you. Section 23A involves the hiring of contract and panel attorneys. One of the things that we looked at when we got the draft back from the Legislative Counsel Bureau, where we sat down again with the Washoe County Model Plan, the Clark County Model Plan, the federal policy guide on model plans, and did kind of a compare and contrast to see where gaps were in order to achieve consistency. And guides for the hiring of contract and panel conflict attorneys was one of those areas. So that's where this provision came from. Again, consistent with the general standard in Section 23 of an independent defense function, this recommends the creation of a selection committee. Again, these are concepts that are already in the Washoe County and Clark County model plans. In selecting and hiring contract and panel conflict attorneys. It also suggests that we remove prosecution or exclude prosecution and law enforcement from the process. Now, one of the things that is in here is, again, one of the concepts that was taken and relocated from Section 23, and that's judicial input in the hiring process. One of the things that is different here is that in the Clark and Washoe model plan that completely excludes the judiciary from those selection committees. I guess given the paucity of attorneys in rural areas, the concerns that we were getting back was that excluding judges, from providing their input would almost be an impossibility or not really feasible. And in turn, part of our I guess part of the board's duties in 18320 is to provide a comment process for the public, generally including the judiciary, on the quality of representation. So that's reflective of this language that input from the judiciary should be considered, but not be the sole basis. Other than that, subsection C provides additional guides without limitation. It's not limited to these 5, but considerations for making those determinations.
Comments on that? Judicial input. So I'm just having a little bit of trouble with my drafts connecting the language. Can you just point me to exactly where the judicial input is on the section?
So we're in section 23A. This is page 15 of the department recommended revisions. And if you look at subsection 1B, the last sentence.
PowerPoint.
Okay. So that's judicial input, but not decisional power.
There's a question of what about
This, Madam Chair, this is Julie again.
Yeah, go ahead, please.
So, and that's just on this is on putting together panels for like a contract attorney, correct?
Correct.
Okay, thank you.
I just want to make a note here. I see we have a question from Judge Schlegelmilch in the chat. I think I neglected to say earlier that you can also email comments during the meeting to Ms. Atanasio. It's fine to make them in the chat. We'll make sure that we capture those as well. But I think I neglected to say that earlier. So I'm not sure, Ms. Reba and Mr. Hickman, if you've seen that comment, which is what about cities and municipal courts?
And we're confused as to what specifically Judge Schlegelmilch is referring to. Is he referring to a question about plans, or is he referring to a question about the contribution? I guess we're unclear.
Oh, good. Judge Schlegelmilch, are you willing to just speak for a moment?
Sure.
Great, thank you.
Okay, well, all the above. There's no funding mechanism to the cities nor plan for the provision of indigent defense in relation to their municipal courts. So I think that's even more important in light of the recent decisions in relation to domestic cases. So I'm just saying, and their probable increase in their budgetary requirements as it relates to it. So A and B, everything relates in the regs to counties. So what about the cities and the municipal? Lyon County has 2 cities that we're the appellate court for. So the question is, what are the requirements going to be in relation to the cities, and do they need to provide plans, and are their budgets going to be supplemented because of their lack of funding in relation to, especially in light of the new jury trial requirements in on domestic cases. So that's my comment. Thank you.
We also have a comment from Mr. Tellis. So, Ms. Reba or Mr. Hickman, do you want to address that directly or here first for Mr. Tellis?
So we're reviewing the NRS specifically for the language. The maximum contribution plan for NRS 180.320 is limited to counties. It doesn't necessarily point out municipalities or cities. So I would think that their budget could be built into the maximum contribution plan on behalf of the county. And then the plan, the submission has to be done by the county, but we're looking at specifically that language.
Okay. Mr. Tellis, why don't you go ahead?
So, just going back to 23A B, just a question. I know we were talking about, again, these committees that can be created and the judicial input being considered, but how does that typically work? If there's not a member of the judiciary on the committee, how would that input be solicited? Would, again, my apologies, but can you just tell us what the vision is for a committee that would just seek judicial input?
Go ahead, Mr.
I think it could be in a number of forms, and one of the things that I guess that may be a comment on broader things. We tried to write these with a degree of flexibility that didn't mandate one particular solution to any issue, but it could be in the form of a non-voting member of the committee. It could be in the form of the committee soliciting feedback from persons in the locality. It could be in the form of comment. One of the department's duties is to create a list of eligible indigent defense providers in rural counties or counties with a population less than 100,000. It could be in the form of comment to the department. So I think there's a number of different solutions of there that would work.
Yeah, Rob, this is Drew. We routinely yearly reach out to the judiciary for feedback. It's not dispositive of someone's tenure on the panel, but it obviously is important information we consider with all others. We routinely have applicants who will submit letters of recommendation from the bench, but there's no formal judge on the selection committee itself. We'll always take input from a variety of stakeholders on someone's qualifications. And so that's how we do it here at Clark. And I assume that's similar to what we're talking about with the board.
I think the idea is to exclude judges from deciding, but not to exclude them from the decisional process, right? To include them as well as perhaps other people who are going to have useful comments on whether someone is qualified and doing a good job.
Thank you.
Okay, so other comments on 23A, or can we move on?
Madam Chair.
Oh, I can't tell who that is.
Bevan Lister.
Please go ahead.
So one of my questions is in this is 1 subsection CI or C1. Ensuring that the applicant is on the department's roster of eligible providers. So I'm new enough to this. Is there currently a roster of eligible providers in the department? And if so, what does that process look like to be an eligible provider? And is licensed with the bar not sufficient?
Mr. Hickman, do you want to address that?
Yes. Thank you. Currently there is not a roster of eligible attorneys. Essentially, the next grouping of categories dealing with qualifications deals with the qualification process and the formation of that list. I think while I would say the department's generally aware of who's working where, the we've been waiting on the formation of the regulations and the qualification process to begin formation of that list. So I think that's part of the workup that's going to be taking place in the initial 180 days, whatever time period before the implementation of the plans.
And the statute specifically says we need a list, right? Do you want to point that out piecemeal?
And that's a good point. And thank you, Director Reba. One of the duties of the department in 180-430 is specifically to create a list of eligible providers in the counties with populations less than 100,000. And that's where the specific qualification, the application process will come in the next grouping of sections.
Ms. Easley, I see your hand is up.
Yes, thank you. And my apologies for before. I just noticed the hand raising function. So my apologies. My question is about the roster of qualified attorneys. Can an attorney, when they indicate that they want to provide indigent defense services, exclude themselves from representing certain counties? In other words, can they say, I'll only go to Washoe and Clark, or once you're on the roster, you have to serve everywhere? Thank you.
No, the intent is not to serve everywhere. It's to provide a list of, for boards of county commissioners to consider when they're deciding whether or not to create a public defender office or use contract.
Oh, I see. Okay.
So it's in the application that we'll create there will be specifications on where an attorney wants to, where an attorney is applying and what qualifications that attorney has. So it's not, once the attorney applies, they're able to go anywhere. They'll tell us kind of where they seek to be.
And thank you. That was my point. If they could say, I don't want to go to Esmeralda or Nye or Mineral County.
Okay, I was hearing somebody else's voice. Is there another comment?
Yeah, this is Chris. Also, just to comment that as the qualifications are looked at, the whole point of all of this is to make sure that we have attorneys that are not just bar certified. They actually have to have background in death penalty cases. That's always an argument that's made that the folks did not have the adequate representation. So I'm sure that that'll be part of what people vet, correct?
Yes, that is the next grouping, and we'll get into those qualifications in that next grouping. But 18320, I think it's the very first of the board's mandatory duties is to provide specific qualification, specific experience and qualification standards. So those are in the next grouping, and we plan on addressing those here momentarily.
Okay. Can we press on, Mr. Hickman, to the next section?
Thank you. Section 24 is the section that deals with screening, prompt appointment, counsel at first appearances. This revision, again, was prompted by comment to the original Section 23 in the LCB return. There was some confusion as to whether or not the plan was trying to take the appointment power or the determination of eligibility power. So we sought out here in Section 1 to discuss only the screening process, that is the gathering of information related to indigency, so that a court has the information to make a timely determination of eligibility. Subsection 2 deals with the prompt appointment of counsel and the requirement of a plan to outline what process happens when the front line of indigent defense is unavailable by conflict or other disqualification. Paragraph 3 deals with the assignment of cases where a public defender office is not used. So the contract attorney situation or the panels of conflict attorneys. It is suggested that the department or the department's designee may be involved in that case assignment process. but in any event, the distribution should be on a rotational basis or other method that ensures fair distribution of cases. Paragraph 4 deals with attorneys at initial appearances in accordance with Nevada statute and recent case law. One of the public comments that we received as we were working through the revisions included essentially the holding from the recent Valdez-Jimenez case. So we added the language in accordance with relevant statute, rule of criminal procedure, and case law. And then subsection 5 is a restatement of subsection subsection in 171.188 that nothing in this section is intended to preclude a defendant from declining to request counsel if that's their choice.
Madam Chair, John Lambros would like to ask a question. I believe he's unable to raise his hand. He's on the phone, I believe.
Go ahead, Mr. Lambros.
Thank you, Madam Chair. I don't know if can you hear me all right?
Yes.
Oh, good. The only point I wanted to make had to do with independence from the judiciary. And I just wanted to remind the commission that with regard to selection for contract counsel and panel counsel, when the Indigent Defense Commission was established in 2007, one of the subcommittees was obviously the Rural County Subcommittee, and that subcommittee was headed by Judge Papez, and I was on that subcommittee with him. And the reason that the rurals were unable to come to a model plan, and I know that I'm maybe telling you things that you already know, but I think it's important to remind the committee on this record. The reason we were unable to come up with a model plan the way that Clark and Washoe were able to do was precisely because of the fact that, you know, it really was not going to work without what we have in place right now in 2020, and that is a Department of Indigent Defense Services. We really needed to admit the fact in 2008 that we needed the help from the rural judges to implement a system that worked. That was contrary to one of the underpinnings of the Indigent Defense Commission's creation. And as some of you may remember, one of the problems, and this was a Clark County problem, I don't mean to suggest that this was a statewide problem, but it was a Clark County problem, and that was the judiciary was far too involved with the appointment of counsel, and there was a lot of cronyism involved, and the Los Angeles Times did a very thorough report on that. So in an effort to avoid that type of cronyism, we tried to implement a rural county program that we thought would work, and we deferred it. We deferred it until we could, and frankly, I never thought it would happen in my lifetime, but it's now happening. And we deferred it until a point in time in which a commission like you all could oversee a department like Marcy, Jared's, and Patrick's in an effort to put together the type of various model plans that would fit within the contours of various rural counties. So having said that, the only other thing that I would mention is, to me, the two most important things that can come out of these regulations are, one, to ensure that the counties are not responsible for having to pay, in my opinion, any amount of money to supply rural indigent defense, because it's not their job, and it's not and they shouldn't have to do that under the Sixth Amendment. And two, that to the extent that there can be a plan workable that in the rural counties, that plan ensures that there is sufficient independence from the judiciary in terms of selection of conflict or contract counsel. And by that, I'm not talking about the kind of really important input that a judge can give, as Drew pointed out earlier in this meeting, the kind of input that they get in Clark County, Drew's selection committee gets in Clark County, but judges do not sit on Drew's selection committee. So I just wanted to kind of walk down memory lane and remind this commission that this is a brave new world, and I think that now with Marcy's help and this commission's guidance, the kind of plan that works in Washoe and Clark can one day work in the rural counties. Thank you very much, Madam Chairman.
Thank you. Mr. Escada, is your hand up?
It is. I just had one comment. If we're going back to section 24, which Mr. Hickman was addressing.
Yeah.
On 24, section 4, I appreciate the changes that were made. I suggest, and I recognize why they don't want to put in the entire holding, but I would suggest editing out on the second line where it says, and prepared to address appropriate bail and release conditions, removing bail and. So it just says, and be prepared to address appropriate release conditions in accordance with statute, rule of procedure, and case law. Because bail is a last resort according to our new, the Valdez Jimenez case. There's a presumption of release. So that I think that the word and that appropriate bail should be removed.
Thank you for that. The additional comments on section 24?
This is Julie Kavanaugh, Bill.
Go ahead, and then I'll get to you, Mr. Wells.
Thank you, Madam Chair. So just to be clear, so section 24, paragraph 1 states that the plan must provide the indigency screening process necessary for the judicial determination. And then the next line on the next page states that the process of screening must exclude the judiciary. So the screening process to determine if the individual is eligible is done by a non-judicial officer, correct?
Mr. Hickman, do you want to comment?
Yes, that's accurate.
And then the second step, it then goes, once they've been screened as eligible, then that defendant would then wait for the judicial determination on the actual appointment. Is that correct? Which would be done pursuant to the plan.
Correct.
Not just on the judge's discretion.
Well, so, I mean, yes, the judge is determining eligibility, and I guess the term appointment in terms of, is a person eligible for indigent defense counsel? And then the plan kicks in as to where that goes. Whatever the frontline provider of indigent defense services is, whether it's a public defender office or contract attorney. And then if that front line is unavailable, the plan outlines where it goes next.
Okay, so that individual does a screening process pursuant to how it's set up in the plan. Could that be a staff member? Because I know, like in Justice Court here in Elko, they have their first appearance and the person fills out that application right as they're waiting and hands it over to one of the clerks. And then the clerk goes through and checks off whether they meet the eligibility requirements. Would that still be the? Sorry.
I'm sorry to interrupt. Go ahead. Please finish your question.
No, go ahead. Go ahead.
Okay. I would say, in terms of who it can be, there's, again, this was kind of written intentionally open to allow some flexibility. What we've seen after, I guess after the Davis settlement, Davis settlement agreement was entered is a number of counties are doing it different ways. Counties that have court services officers, or pretrial services officers are using those officers. Some counties have entered into MOUs or memorandums of understanding with, the sheriff's office, who can do the indigency screening pursuant to a standardized form as part of the intake process. I think others have used, the Department of Alternative Sentencing or the like. So there's a number of ways that it could get done. I guess the second part of your question was, could it be done at the initial appearance? And one of the things that we're trying to encourage here is that it be done, kind of in conjunction with the probable cause finding, the McLaughlin probable cause finding, so that, when the judge takes the bench at the initial appearance, all that is ready to go and can be done quickly and facilitate the appointment of counsel, in a manner that gets attorneys, notice and time to prepare and speak with the client.
Thank you. And just to correct, I meant the first time they appear. I didn't mean first appearance hearing, so.
Okay. I think, Mr. Ariscotta, you don't still have your hand up. Is that correct? Good, thanks. So I just have a very minor comment on section 24, which is in section 5. I think you might, instead of using the word declining, which comes from the statute, I realize you might want to use the word waiving counsel, because that actually better captures what both I think the standard is, as well as it's also expressed in the statute, which talks about a knowing and voluntary waiver. So just a minor suggestion. Can we move on to 25?
No, I still have a comment for 24.
Please go ahead. Sorry.
Paragraph 3, I'd like us to delete the second sentence. The second sentence says cases may be assigned by the department or the department's designee. We assign dozens of cases on a daily basis down here. Obviously, our plan has it set up so Drew in his office assigns cases. If they're not track cases, we put the track things in, track attorneys in that are assigned for rotational within various tracks. I just don't know how that line even remotely works in the big counties, and quite frankly, I'll defer to Dave and Lorinda, but I'm not sure that even works there. I mean, by the time the case comes in and has their initial appearance, we're going to have to now wait for the department to decide who to do it and not let the judge do it off of somebody who's on the department's approved list. It just doesn't make any sense to me to have that in there.
Mr. Hickman, is there maybe thinking behind that would be helpful?
The genesis of that was consistent with, our bill draft request, and that's, the independent of selection of counsel. The language, I think, in the original draft was, mandatory language and, applied to, I think, counties less than 100,000. Based on comments and concerns that we took in from rural judges, we changed that to discretionary language. So, the intent of that was to provide that as an option if a county wants to, not to require it. And then also the concerns were with the same concerns that you have regarding the department making that appointment was a reason we included or its designee language so that if a county chose to create a Mr. Christensen Office of Appointed Counsel to handle these duties, they could, that person would obviously be the designee to handle that task.
Then let's just add some language at the beginning of the sentence that says, if requested by the county, cases may be assigned by the department or the departments.
Ms. Wickman, do you have your hand up?
Only to respond to Jeff, and yes, I agree. Thank you.
Thank you.
Thank you.
I'm sorry, I haven't figured out how to raise my hand. It says I can't raise my hand on my little screen.
Okay.
This is Laura Fitzsimmons.
Please.
That makes a lot of sense as long as because I sat on the last, the previous governor's task force on this, and I don't know if Justice Maupin is still on the phone or participating, but certainly, our committee was responsible for the bill, which became law, which is why we're all here together. Please forgive us all. But I think that we all agreed, Joni, I don't know if you recall this, and I can look back, the idea of judges appointing counsel was just not acceptable. I understand if there's a roster and the judge, if there's screening and they're good lawyers and there's a roster, the judge can appoint at first appearance or whenever in the proceedings it's appropriate in sequence from that roster. I think that's pretty much what's going on in Clark, but what Jeff just said, I want to make sure does not, or suggest it does not undermine that process where the judge just appoints the next person up unless there's some reason they can't take it.
Laura, I do recall that we had a lot of conversation on that in the early days.
So Laura, I can only speak for Clark, but in Clark, we have, I think, 54 or 72, I don't remember right now, general track lawyers. So we assign them to each of the justice courts, and then from the justice court, they're tracked up to district court. So I may have assigned 3 lawyers to each one of the criminal justice courts. So Drew does those assignments to the track, then the judge rotates between those 3 within the track. But then when we have special cases, a murder case comes by, any category A felony type case comes by, then the clerk for the individual court calls over to here, and then Drew assigns them off our master list. If it's a murder, he looks for the 250 qualified, he does that. So the court never gets to pick who the lawyers are that are assigned to their track in the first place, nor do they get to do any of the category A cases.
And that sounds perfect.
Chair, you're on mute.
Sorry, Mr. Picker. I'll go to you, Mr. Picker, and then we'll circle back to Drew Christensen. Go ahead.
Thank you. I just was going to add, just to give you the Washoe perspective, we too have a list. It is not judge selected, although we do get input from the judges on performance each year and that kind of thing. But we have an administrator just like Drew is down in Clark County, and she has a list and she rotates through them. And that's how and we don't have anybody as track attorneys. It just rotates through on all cases that come up. And we have a small group of 250 qualified, and we also have an appellate group and a habeas group as well to take those kind of cases. So that's all part of the plan, the master plan that is approved by the Supreme Court under ADKT 411.
Thank you. Mr. Christensen, I'm coming back to you with apologies.
But that's okay. I just was going to confirm that's in Clark County. It's morphed over the years where we have a pretty good system where the track attorneys that Jeff spoke are assigned to the courtroom. So the judges have no input on who appears in their courtroom. Once those 3 are assigned to that courtroom, the clerks are pretty good about just rotating those 3 as appointments come up where there's conflicts with the institutional offices. And then monthly, those attorneys report to us how many cases and what type of case they picked up. And so we monitor that each attorney within a courtroom gets approximately the same number of cases per month. And then if it's a more significant case, and we define the significant case by if they face a life sentence in prison, then the courts will contact me, and I'm routinely busy in the morning handing out appointments, and I'll equally distribute them to the variety of people on the list who are qualified at that level of representation, whether it's a sexual assault case, 250 case, whatever it may be. And so we look routinely at the numbers on who's getting what cases and try to equally distribute them. So by definition of a list, it's worthwhile to know we try to equalize those appointments within those categories of lists.
Okay, useful. Let's see. So, Mr. Hickman, I think you can press on. I think, or maybe we're at 25.
Thank you, Madam Chair. Section 25 is a section that deals with client communication. As you can see, there's some significant proposed deletion of material. Essentially, addressing that first, since there's a lot of red on these pages, the sections that were deleted imposed what I'd call specific attorney performance requirements related to client communication. One of the things in going back through the Davis settlement agreement and listening to some feedback from interested parties was that, and I think this is consistent with Mr. Wells' comment at the outset was that rather than incorporate the specific attorney requirements, make general reference and incorporate the attorney performance standards in ADKT 411 that already deal with client contact, as well as the rules of professional responsibility and those ethical norms. So rather than list specific attorney qualifications, we are proposing that we remove those and then just require that the plan seek to provide those resources and accommodations for confidential client communication through cooperation with local partners. And again, the language did change from ensure to seek to provide. Some of the commentary and feedback we got back from I think Clark County, a number of the rural counties, was ensure may be impossible to accommodate for every attorney. Limitations in jail size, things of that nature. It needs to be more of a make sure it's there, but it cannot accommodate confidential space for every single attorney that may be wanting to visit a client at one particular time. So that's the basis for those revisions.
Okay, comments on 25? Let's push on to 26.
Section 26 deals with the plan ensuring resources for experts, investigations, and other case-related expenses, and then also discusses the recommendation for payment of case-related expenses. This is a section that was relocated from the original 23, and through a lot of discussion with interested parties, a revision to the recommendation that is contained in paragraph 2. The paragraph 2 is the new section and consistent with the general standard in 23, and that's the independence of the defense function. The recommendation is that in counties less than 100,000 in population, if there is a public defender office, that a budget is created for those case-related expenses that can only be used for reasonably necessary expenses. Where there is not a public defender's office or where there are individual appointments, it still recommends creation of a separate and independent budget for those expenses. The department's involvement would be to make a recommendation on requests that come from attorneys needing funding. And then we will promptly, within 2 judicial days, send that recommendation to the court, who will then approve, modify, or deny. And then make, ultimately the decision part of the record. One of the things that was our concern was, speed in which, and frankly, a lot of the interested parties' concern was speed and kind of flexibility for those requests that are, I guess, routine. So one of the things that is considered in paragraph 2 is the automatic approval of a request up to $2,500. By the submission of an order to the presiding judge in order to expedite those routine submissions. And then with respect to counties in excess of 100,000 population pursuant to the already established plans.
Comments here? Anyone? Okay, good. Why don't you move on to 26A?
Thank you. 26A is the provision regarding vertical representation. That is essentially, this has just been relocated in the version that came back from LCB. This was in section 41, and it didn't make sense where it was located, so we brought that up and changed that to indicate a county plan shall ensure. And then the language is the language that came out, that is the statutory language, 18320, subsection 2D5. Then subsection 2, again, this is not changed, but the intent here is to require vertical representation consistent with the statute and provide some flexibility for manners and the manner in which things are done based on local needs.
Okay, I'm seeing a comment. Judge Schlegelmilch, would you like to comment?
Yeah, and it was actually on the prior subject, and I tried to get my hand up when you said any other comments.
Okay, go ahead.
All right, so AB2 subsection 2, if it's denied, if an expense is denied, it goes to the judge. All right, so like in my district, okay, we have 2 of us, so we don't have a presiding judge, but I'm the judge administratively that handles all the budgetary issues, and I know Judge Aberstary would likely not want to even look at my cases in relation to what I'm approving in relation to expert witness fees or not. I don't know if that's meant as a checkpoint to, but according to this, I would have to certify it and send it to Judge Aberstary, who doesn't pay because he has more years in service than I do, who doesn't have any budgetary, well, who doesn't deal with the budgetary issues of the court. I mean, we always discuss them, but as a practical matter in relation to signing off and approving bills and those kinds of things, and for approval, I mean, we always, so I don't know why the secondary provision is in there about the presiding judge having to have to approve it versus the certified, if the trial judge certifies it and approves it. I don't understand why that would be there.
Sorry. Mr. Hickman or Ms. Rubin, do you want to walk us through just sort of how the mechanism works or is meant to intend the thinking behind it?
I guess I just want to make sure we're looking at the same language, Judge. Are you referring to the last sentence of 2A2 that says, in the event the presiding judge denies the application in whole or in part, the judge shall enter written findings of fact under seal?
No, I'm looking at, all right, so it's section 2, it's section 26, subsection 2A.
He's not looking at
B,
the
II.
No.
What's the problem?
Oh, I think I see our miscommunication here, Judge. I think you might be looking at the return from LCB.
No, this is the new draft. It's green. It's in green.
It's November.
Is it dated November 23rd in the bottom right-hand corner?
No, it's dated November 6th. I didn't get anything that was dated November 23rd. Okay. I apparently don't have the most recent one.
It is on our website, Judge.
Can you just read the language just on that?
For some reason, I can't get to, the county blocks it, so.
I'll tell him right now.
We're going to email you right now, Judge.
And
all right,
this is Julie Kavanaugh. Bill, I've been looking at the language because I had a question mark on it too, so I think I have the language up in front of me that Judge Schlegelman is mentioning.
Mm-hmm.
And let me know if I'm wrong, Judge, but I'm reading, upon receipt of the recommendation, the presiding judge shall promptly rule on the application. And then it goes on, in the event the presiding judge denies the application. So what I'm hearing is you're saying, and we don't, here in Elko, we don't have in the 4th Judicial, we don't have a presiding judge right now either. When we get our 3rd judge, they'll make someone the presiding, or the senior judge. But I'm wondering if we can, instead of saying the presiding judge, because in some counties, like, you know, what Judge Schlegelman is just saying is one of the 2 judges is making those determinations, not both of them. Can we say that the plan shall identify the judge to which the application will then be sent? So then the county can craft it the way that it works best in that county or in that district?
Mr. Hickman, do you want to, are you?
Statutory language.
We were, so thank you, Chair Trum. We were just having a little bit of internal discussion. I guess to answer a couple of questions at once, the choice of the presiding judge language came, I think came from looking at NRS 7135 and the requirements of that statute, specifically paragraph 2. Relating to the payment of expenses approved by the presiding judge of the judicial district. With respect to those circumstances where there is no presiding judge, I would say that 18320 only provides us authority to make a recommendation. And so I think if a plan substituted trial judge instead of, I don't think there would be any issue there.
Okay. All right, that's helpful. So that was, this is on, sorry, 26A. Did you already talk about 26B, or have we not gotten into 26B yet, right?
Madam Chair, it appears Drew Christensen has his hand up.
I apologize, didn't see that. Mr. Christensen, go ahead.
Yeah, I don't want to just comment on Judge Slaven. I don't want to throw a wrench into Section 26, but I too had a note there, and I'm not sure of an answer. But the concerns, I know that Section 2 mirrors 7.135. That's, no one's ever bothered to change the statute. That's actually in opposition of what ADKT 411 has. You know, ADKT 411 suggests that the judiciary should have independence from the defense's pursuit of their case. For example, in those counties that have a public defender, they're budgeted for their experts and investigators, and that's an internal decision that the office makes on when to use experts and investigators on a particular case, and no one, the court and or the prosecution, will never know the use of them, right? And so somewhat the beauty of the plan that we have in Clark County is we treat the private contracted attorneys just the same as institutional lawyers, where they come to the executive branch and ask for the investigators and experts. The only time it goes to the judiciary is if the attorney is not satisfied by the executive branch decision. I want to hire this expert, and for whatever reason, let's say we deny it. We can have a hearing in front of the court. But having the court have, to some extent, I get the department is going to make a recommendation, but the court makes the final decision, bothers me a little bit. And I don't know in some of these smaller rural counties how you get away from that. And I know that's consistent with the statute, but I think the intent of ADKT 411 was to treat the defense so it's independent of the judge's decision on what experts and investigators they can utilize. And so just like I'm sure Aristata in Washoe, if his deputies want to use a particular expert, it's his kind of call. And no one ever knows if we use them or not use them, right? But if I'm a private practitioner in whatever county, I need to seek the court's approval to hire this expert. If it's denied, I at least want to hope, and I like the part that there's a record made, so that if there's ever a appellate or habeas issues, it was known, but for the fact that I wasn't able to use this person. But I don't know how that language can be written better. I mean, it is what it is. And I just want to throw that comment out there. So the department's aware when they make a recommendation that there needs to be a record of that if it's denied.
I'd like to go to Ms. Fitzsimmons and then Mr. Aristata. Go ahead.
Thank you. This is the other point. I'm sure Joni recalls this, and Justice Maupin. This is key. The prosecutors have the ability to use any expert they want, and the judge never hears about it. If you have to go to the judge for approval, or in my opinion, even notice, and I understand what they're faced with, Chapter 7, the judge is going to know, okay, well, they hired so-and-so, they didn't use them, so that means they're expert. I mean, I'm working on a case right now that it's just a nightmare because you're entitled to seek the opinion of an expert, and if you don't call them at trial, the judge, like any other reasonable human being, is going to think, well, they piled on too. So it's a disclosure of our defense strategy to, in some instances, the trier of fact, and in all instances, the sentencing judge. And I just really feel that if either the prosecutor should have to go through the same hoops, or indigent defense counsel should not have to go through those hoops.
That's why I brought it up.
I want to go. Thank you. I want to turn to Mr. Arascata, and then I see Mr. Lambros figured out how to raise his hand, which is awesome. Thank you.
Yeah,
So, go ahead, Mr. Arascata.
Yeah, just to answer Mr. Christensen's call, yeah, with our PD's office, APD's office, and even our tertiary group, which is our appointed counsel list, none of them have to seek judicial approval on the hiring of an expert or for investigative costs. It's either approved or denied by our appointed counsel administrator or by myself or Mr. Picker. I appreciate the statute, but if the purpose of these regulations, we were just discussing the appointment of counsel to remove the judiciary from the appointment of counsel. It seems even more significant to remove the judiciary from the approval or denial of costs and expenses to defend a case.
Okay, thank you. Mr. Lambros?
Well, I would echo what Mr. Arascata just said, and my point would be this. The goal of the rural subcommittee, and I think the goal of this commission, has always been to reach a point where contract counsel is placed on the same footing as retained counsel or an institutional defender office counsel. And that's a riff off of what Mr. Arascata just said. In those instances, retained or institutional defender office, a judge never, ever is party to that discussion or that strategic plan. And that is, to what extent do you want to hire an investigator and or an expert witness, and how much is that person going to cost? Those cost benefit analyses are done in the retained scenario between the lawyer and the client, and in an institutional defender scenario between the line lawyer and her supervisor. The contract counsel does not have that benefit. Now, I know, and again, Drew can speak to this maybe a lot better than I can, but in Clark County, the 8th Judicial District, I think, has been able to somewhat finesse that and go through Drew without having the judge's nose under that tent as significantly as it is as it has to be. And again, I acknowledge Chapter 7, and I know that it's an extreme difficulty in trying to fix this problem. But I think one of the principal components of the Davis lawsuit was to get to a place that Mr. Arascata just described, and what I'm trying to describe myself, and that is where contract counsel or appointed counsel does not have to do the same things that his colleague or in the private bar or his colleague in an institutional defender office does not have to do. That's the goal that I think this commission needs to get to. And I think that if the commission doesn't strive to get there and get there soon, there could be problems with the milestones that are supposed to be met under the stipulated settlement in the Davis lawsuit. So I'll throw that out there, and I tell you, it was something that was extremely important to the conversations that the rural subcommittee had over the 13 years that we struggled with this in the Indigent Defense Commission. Thank you.
Thank you. I guess, I apologize, I'm making noise here with my printer. I guess one question is, do Mr. Hickman and Ms. Reba, do you feel like you've gotten suggestions that are sufficient to kind of cover the ground? Because it sounded like in the draft we're sticking with the statute, but there's also been a critique that maybe we should have substitute language that better captures the goal of the commission and the relevant standard. So I'm just wondering, is there a need for proposed language, or do you feel like you've got enough to work with now?
So we were just talking back and forth in terms of comment. Yes, the language does track the statute. We did insert the department recommendation is in excess of the statute. This is the area where we, from the initial draft to where we are today, that drew the most concern. We looked at this from several different angles, but ultimately, what we're up against is Chapter 7, and an agency regulation can't conflict with existing statutes. So we're up against Chapter 7. We're up against the language, the enabling language in 18320, which is to provide a recommendation. We could make the recommendation stronger, and we're certainly open to, because we certainly don't disagree with anything that's been said. This language was reached as kind of a compromise to draw in, to get the department involved in the process, but also at the same time acknowledge existing law. Now, the backside of that is, I'll note that our bill draft request does seek to tackle this issue, because that may be the more appropriate forum to address the issue. So we're trying to work on it on multiple fronts. But certainly, if someone has better language, we're open.
Okay, I'd like to get to Ms. Thomas. You have a comment?
I do. I agree with everything that's been said. If the decision is made to follow the statute, I think it is important that it be the presiding judge where that's an option, so that it's not the trial judge. In the 8th, if we had the ability to go to Judge Bell rather than the trial judge, that would be a better option. I realize not all of the rural jurisdictions have that definition, but maybe it could be defined as someone other than the trial judge.
I think that's a useful suggestion. And I also think that one way to kind of tag that this could be subject to change is you could have some language in there that says what the department wants, and then say, except to the extent required by some other statute, right? Like that kind of flags that issue. Go ahead, Ms. Fitzsimmons.
How do Washoe and Clark counties work around the existing statute? Because what I'm hearing is, no, but I mean, it's a huge equal protection argument, right? It's just ripe for litigation, and Clark and Washoe counties, I'm pretty sure, have recognized that and avoided it, taken that issue off the table. I mean, I will tell you, this is something that I think a number of us who've worked on this for years, and many members of this commission, feel very strongly about.
Laura, this is Drew.
Okay, go ahead.
Yeah, luckily we had buy-in when Clark County put its model plan together in 2008. We had agreement from the bench that this was in the best, considering what the ADK 411 ruling was, that this was in the best interest of the system. And so the budget that was previously for private attorneys, investigators, and experts was transferred to the county manager's office. And so they actually liked the fact that they didn't have to deal with that anymore. And so even though the statute exists by kind of a model plan agreement that was signed off on by the court, it's been in existence for over a decade, where we just wrap around that statute. And so the only time we ever go to the court is if I and the attorney can't come to an agreement as to what's reasonable and necessary in a particular case. Luckily, that may be a handful of times over 10 years. So it doesn't happen a lot, but that's our due process judicial involvement. If the contract attorney feels that the executive bench is not allowing them to be effective in their representation, they come to us. And so it was just the concept of a model plan and the transfer of the budget. So that money that was designated for the experts and investigators is no longer under the district court's budget instead of the county manager's budget.
Just in light of that, just one more, because I don't know a thing about budgets, but Marcy and Jared, if we have a cap, we all agree that the counties, and that cap's going to be bumped up against, in every county functionally pretty quickly. If we were just to take into the commission the payment of expert fees and all expenses, so they're paid by the state, then it would seem to me, I heard Judge Schlegelmilch talk about he's responsible for the, for the budget or the court's budget or whatever. We would just take it away from them, right? And they're still gonna hit their budget. We know we're gonna have to pay more. And if we just say, okay, we're taking in this category of indigent defense into the state budget, would that work, or does that create a big problem?
Marcy,
I mean, I think that Jason Colnut is on the line. Currently, when we do post convictions, we need an order from the court to be able to pay certain things. I don't know how we'd be able to break up by county in our budget build, what would be requesting. I think what we are currently proposing is a reimbursement process where the counties are reimbursed for these costs and they pay them first, then we reimburse them. So, I mean, that was kicked around that we could create a budget within our department. Again, there's a question of whether we'll be getting funding for that in the next legislature, whether or not that would be supported, but that was something that we had thought would be a solution to this issue, because expert witness fees, I think, are excluded from the maximum contribution of the counties. So, possibly that is a solution that we could have them put in their plan, that the budget would be built within our department for their max contribution or a certain amount.
Okay.
This is
sorry.
Chris. I don't know how my flag won't work.
Okay. Christine, do you mind holding up? I do want to get to Judge Schlegelmilch, who just had raised his hand, and I've got my eyes on it, so then I'll come to you next. Go ahead, Judge.
Yeah, as a practical matter, it really doesn't make that much of a difference, because I can't recall a situation where we don't approve the expert witness fees or the investigator fees when it's requested in the amount that it's requested. So, I mean, as a practical matter, it really doesn't make a whole lot of difference. As a statutory matter, I think it does make a difference under Chapter 7. But, I mean, who actually gives out the money? So, one way or another. The problem I have, and then you get into other issues like WITIS issues, whether or not the court's going to pay for, or the county, whatever the indigent